Delivery of order.
May I please, your lordship?
1 minute. Delivery of order. Delivery of order, item number 45.
All right,
Yes, ma'am.
rejected.
Rejected.
Lordship, item number 44, lordship.
Yes,
Lordship, in this case, lordship, the accused person is behind the bar from January 2023, more than 2 years, lordship. And the LCR received on dated 9/12, 2024. So I beg to mention for upgradation in this
Today?
case. Yes, lordship.
at 2 p.m.
Okay, lord.
How many days you are behind bars?
More than 2 years. 2 years.
2 years.
3
And
months.
what is the offense you are convicted of?
22C NDPS.
22C. How many years? 2 years, more than 2 years?
More than 2 years. 2
22C
years, 3
NDPS.
months. And it is
10
listed
years,
in
10
diary sheet.
years, 10 years. 10 years
Lordship, 10 years,
imprisonment.
10 years, with a fine of rupees 1 lakh.
At 2.
Lordship.
You want it at 2?
Yes, sir.
Okay. All right.
2 p.m.
May I please, Your Lordship? Lordship, I think you mentioned for listing of an IA connection with criminal appeal, where the appellant convicted for 10 years. And as of now, Lordship, he is completed 3 years.
70.
7 days, Lordship. Deeply urgent, Lordship.
May it please, Your Lordship, listing of an IA for criminal appeal, Your Lordship. Can it be next week, Your Lordship? Oblige, Your Lordship.
May I please, your lord? In item number 23, lordship, CD is not available.
CDS call for is not received. Issue reminder, list the matter on.
On 6 May.
Interim order is.
Interim order shall remain in force till then.
May I please, Your Lordship, I beg to mention listing of a IA for condonation of 54 days, but the party did not appear. Kindly matter may be fixed on day after tomorrow.
2nd April.
Oblige, Your Lordship.
May I please, Lordship? Lordship, I beg to mention for listing, Lordship, is motion, Lordship. Tomorrow, Lordship. Already
What,
filed
what?
yesterday.
What? What
Anticipatory bail, Lordship.
anticipatory bail?
Yesterday, we are.
And not tomorrow, anticipatory bail, you are not behind bars, 3rd of April. 3rd of April,
Day after tomorrow, Lordship.
too much of congestion, too many cases together at the same time. On 3rd of April,
May I please, Your Lordship? I beg to mention for listing a criminal appeal, Lordship, for orders next week. Any day. 10 April. Maybe 8.
yes, can be. Fine, 8th.
May I please, your lordship?
Hmm.
I recommend item number 18, my lord. We have filed an additional affidavit.
Learned Counsel,
Item number 18,
Mr.
my lord. That may come on record.
D. Bora has prayed for it.
No, we have filed an additional affidavit, my lord.
Oh, you have already
Yes,
filed?
yes,
Okay.
yes, ma'am. That may come on record. ma'am.
Okay, okay, yes.
Oblige.
Yes.
May I please, Your Lordship, I beg to mention list for listing of regular bail application, Lordship.
Speaker to.
Lordship, the way number 764.
Etu নহয় সেইটো BA
BA. Same matter fixed on 27 March, Lordship.
same matter
Same matter.
out of the same FIR.
Same affair. Another is same affair.
May I please, your lordship? Lordship, I want to mention regarding item number 29 of date daily list. Matter may be adjourned for the day and any date may be given after vacation.
CDS conference
Interim is
not
there,
received,
Lordship.
issue reminder, list the matter on. Interim order shall remain in force till then.
7-4. 7-4.
May I please, my lord? My lord, item number 30, my lord. Here in this case, my lord, city has come, my lord. My lord, this matter may not be taken today, my lord. My lord, it may be taken on Monday, my lord.
Some other day.
My lord.
May I please, your lordship?
CDS call for is not received, issue reminder, list. Huh, CDS? Okay, okay, okay. Learned Counsel, Mr.
Hey, Manav.
A. Manav has prayed for adjournment. CD is received, list the matter on 1st April. CD to be retained till then.
My lord, interim may be continued.
Interim order shall remain in force till then.
May I please, your lordship. So I beg to mention for listing on criminal petition, lordship, that was last list on 2024, lordship. Can it be 4 and 5, lordship? 4 or 5, lordship.
Yes, can be.
Much obliged.
May I please, your lordship? Lordship, I beg to mention for listing on regular bail application, lordship. Same matter fixed on 27th, lordship. BS 721.
Same matter
Same
on
matter.
27.
27th, lordship.
May I
Ano-
please,
Another lordship. I criminal, lordship. Any date, lordship. My lord.
may I please, lordship, I beg to mention one criminal review petition, lordship, 24 orders, lordship.
My lordship, I file a KPD petition, my lord, and your lordship has issued notice and fixed on last 21, my lord. But due to paucity of time error, the matter has not been reached, my lord. Already the opposite party, that is, Respondent of Theory has already filed Okalat, my lord. Let the matter come on 5th April, my lord.
May it please, your lordship. Lordship, I beg to mention item number 24, lordship. In this case, I'm on interim bail, lordship. Case diary was called for, lordship. Probably it is not
CDS call
arrived
for is
till
not
date,
received.
lordship.
Issue reminder, list the matter on. Interim order shall remain in force till then.
Highly obliged.
For listing on criminal petition,
Hmm.
for orders tomorrow, my lord, urgency is there. For orders, my lord, we will only seek a liberty for filing a prayer for adjournment before the lower court.
Tomorrow
Matter is
hearing day honey. Okay.
for orders. Highly obliged.
Item number 1.
May I please, my lord?
Hmm.
I am, this is a regular bail application. I am on behalf of the prisoner Sumit Das, who was arrested on 18/3/2025 in connection with Palasbari PS case number 9425 under section 296, 351 2 and 1091 of BNS. Your lordship, two other section 296 and 351 2 are bailable, and 1091, that is attempt to murder.
Please read the FI.
As per Azahar, no elements regarding 109, which support the incorporation of 109. FIR is page number 13, my lord.
Hmm.
FIR, with due, now, with due respect, I like to inform you that once Sumit Das has been dangerously posing threat to my life, we have been noticing his doubtful movement and advances with malicious intent to of late. In one video, the culprit can be seen shouting threats me in public, and he is even been dragging and dumping a portrait of me into the river of Brahmaputra. And he is also shouting obscene and foul languages against my mother, who is an old aged woman and holds respect and reputation in the society. But this act has caused serious mental harassment and trauma to my mother as well. This is, my lord. There is no any ingredients which support the incorporation of section
Okay.
1091 attempt to murder.
Okay.
And he's in the behind the bar since 18. My lord, kindly
18.
considering the
This,
allegation.
this 18.
My lord,
This 18. 18.3.
18.3. But in Azhar, no ingredients of section 109. Other two sections are available. My lord. Kindly considering the
Learned Counsel, Mr.
allegations of Azhar.
Naam to go.
El Kulta.
Learned Counsel, Mr. L. Kulta, for the petitioner Sumit Das, who has filed this application under section 483 of the BN. WS 2023 with prayer for bail, as the petitioner is behind bars since 18/3/2025 in connection with so and so PS case under so and so sections. Heard Mr. DP Goswami, learned edition PP Assam. The FIR unfolds that the petitioner has been threatening the informant. The petitioner also dumped the informant's portrait into the river. Full stop. The petitioner also seen shouting threats in public through a CCTV, through a video footage. Stop. It is submitted on stop. The allegation basically against the petitioner is that he has been causing mental harassment to the informant and his mother. So it is submitted that there is no allegation in the FIR that the petitioner has attempted to commit murder of the informant. The other offences alleged are bailable offences. I have considered, I have heard both sides. It appears that bail may be granted to the petitioner. The petitioner is therefore enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the CGM Kamrup Metro,
No, Kamrup Rural.
Kamrup Rural. To the satisfaction of the CGM Kamrup Rural under the condition that the petitioner shall refrain from such activities with which he is alleged. Number two, the petitioner shall appear before the IO on every fortnight till completion of investigation. Number three, the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall, the court is at liberty to cancel the bail granted to the petitioner.
May it please your lordship, regular bail application, your lordship, FIR is on page 8. Your lordship, allegation against the petitioner is regarding theft of 3 cattle, your lordship.
Mm.
And they're arrested on suspicion. 2 cattle are already recovered, your lordship.
Please read the FIR.
With due respect, I would like to inform you that in reference to the subject cited above, it is known from the investigation that Manaf Ali at the rate of Bauna and Majun Ali of Lahargatia village have stolen 3 number of cattle and have kept the cattle in the house of Mul Ali. And from reliable source, it is known they have slaughtered one of the cattle and have sold the beef. And when we came to know, we went to the house of Mul Ali, brother of Majnur Ali of Lahore Khata village.
Okay.
And-
Heard Miss
F. Hussain.
F. Hussain, learned counsel for the petitioners, Tinta ase, 1, 2, 3, who have filed this application under section 483 of the BNWS 2023 with prayer for bail as they are behind bars since 13/3/2025 in connection with so-and-so PS case under so-and-so sections. Heard Mr. DP Goswami, learned additional PP Assam. The allegation against the petitioners is that he, along with the co-accused named in the FIR, have committed theft of 3 cattle, 3 heads of cattle, and also after slaughtering one, sold the beef. Full stop. What is your ground?
Lordship, I arrested only on suspicion and 2 cattle are already recovered, your lordship.
It is submitted on behalf of the petitioners that they have been arrested only on suspicion and 2 heads of cattle have already been recovered. I have considered the submissions at the bar. It appears that bail may be granted to the petitioners. The petitioners are willing to cooperate with the remaining part of the investigation. It is submitted that the petitioners are local residents and they are not flight risks. Considering all aspects, petition is allowed. The petitioners are enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the
CGM Nalbari.
Under the condition that the petitioners shall refrain from such activities with which they are alleged. Number 2, the petitioners shall appear before the IO on every fortnight till completion of investigation, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, the court is at liberty to cancel the bail granted to the petitioners.
Deeply obliged, your lordship. Item 3.
Please, your lordship. Lordship, 482 application, lordship. FIR is on page 11, lord.
Yes.
Lordship, if I may read the FIR, lordship. Lordship, earlier they filed an FIR, lordship, which was not registered. Thereafter, they filed a complaint case in CGM. Lordship, page 11, annexure 1, the complainant begs to state that she and her family were living peacefully at her husband's house. On the day of the incident at around 7 AM, the goat belonging to accused number 1 started eating a bottle gourd plant outside her house. Upon seeing this, her daughter-in-law chased the goat away. This led to accused number 1 and accused number 2 abusing her daughter-in-law with obscene language and attempting to physically assault her. They also threatened to kill the entire family before leaving the scene. The accused persons with a malicious intent and pre-planned conspiracy to harm the life and property of my family gathered together and were waiting at the house of accused number 1. On the same day of the incident at around 9 PM, my son Akidul Islam, was passing near the house of accused number 1. At that time, accused number 3, Shahjamal, caught my son alone on the road, surrounded him and started abusing him with obscene language while threatening to assault him. Hearing the commotion, my nephew, Shakir Ali, and other nephew, Aler Ali, came forward. However, the accused persons forcibly dragged both of them from the road near accused number 1's house and started beating them. When my son, Akidul Islam, stepped forward, the accused persons also brutally assaulted him. Hearing the commotion, I, along with my 17-year-old minor daughter, rushed forward to rescue my son and nephews from the clutches of the accused person. However, the accused caught hold of me and physically assaulted me. Taking advantage of the darkness, accused Hakizul Ali and Tamizul Ali forcefully covered my minor daughter's mouth, pulled her by the hair, and dragged her on the ground. They took her a little further, tore her clothes, and with malicious intent of sexually assaulting.
Yes, 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 yes.
This is an application for anticipatory bail.
Hmm.
As I read at page 11, an extra murder.
We'll call for the CD. Murder
My lord,
case.
it was already in anticipatory bail, my lord. I have annexed the order.
So we'll call for the CD. It's a murder case. Call for the CD along with the PM report. Call for the CD along with the PM report. List the matter on.
My lord, one other case is already in the list today in item number 35.
No,
May I
we'll wait there. Or should we take the item number 35?
Same city. All right, maybe taken with item number 35.
Okay.
Much obliged.
We'll take up with item number 35 there.
Item
cut it,
number 35, we have not received the CD log.
CD is not received.
Then notice me.
Okay. Call for the CD along with the PM report, list the matter on. Item number 35, anybody is present for item number 35? CD as call for is not received. We should remind the list the matter on 7th April, same day.
7th April.
Much obliged.
Item 35 to Danagal Ekiti.
My lord, FIR is page 13. That's the kind of detail.
Yes.
Page 13. So, the petition has been absolutely falsely mitigated, my lord. The petitioner is not named FIR, my lord. Now police is searching. My lord. It is theft case, my lord. Let the city will come and them may be protected.
Who is the FIR?
FIR is page 13.
Can you read the FIR?
Yes. বিনীত সন্মান সহকাৰে জনাও যে যোৱা নিশা মোৰ ঘৰত মানুহ নথকাৰ সুযোগ লৈ 4-5জনীয়া দুৰ্বৃত্তীৰ দলে মোৰ ঘৰৰ দৰ্জা খিৰিকী ভাঙি গোপনে মোৰ ঘৰত প্ৰৱেশ কৰি ঘৰৰ পৰা সোণ ৰূপৰ গহনাৰ লগতে নগদ ধন লৈ পলায়ন কৰে। পাছত আমি ঘৰত উপস্থিত হৈ উক্ত ঘটনা প্ৰস্তুত কৰি তিৱাৰ পাছৰ কৰাত গাঁওবাসী ওলাই আহে আৰু আমি গাঁওবাসীয়ে বিচাৰ খোচৰ আৰম্ভ কৰি দুজন অচিনাকি ব্যক্তিৰ ভৰিত বোকা দেখা পাই সোধ-পোছ কৰোঁ। তেওঁলোকৰ কথা বতৰাত সন্দেহ বজাত আমি গাঁওবাসী উল্লিখিত 1 নং 2 নং প্ৰক্ৰিয়াত তালাচী চলাই তেওঁলোকৰ পৰা নগদ ইমান টকা, এটা মোবাইল ফোন আৰু মানি বেগ দুটা আৰু কিছু নথিপত্ৰ উদ্ধাৰ কৰোঁ। প্ৰতিক্ৰিয়া দুজনক সোধা-পোছ কৰাত বাকী 3 নং আৰু 4 নং প্ৰক্ৰিয়াৰ সহযোগত তেওঁলোকে মোৰ ঘৰত চুৰি কাৰ্য সমাধান কৰা বুলি স্বীকাৰ কৰে। তেওঁলোকক সোধা-পোছ কৰি থকা অৱস্থাত 2 নং প্ৰক্ৰিয়াৰ আণ্ডাৰৰ সুযোগ লৈ পলায়ন কৰে। পাছত আমি 1 নং প্ৰক্ৰিয়াত তেওঁলোকৰ পৰা উদ্ধাৰ কৰা সামগ্ৰীসমূহ আৰক্ষীক চম্ভালিছোঁ। There is the allegation. I am the accused number 3, man. And I am FIR, my lord. Accused number 3. Baharulal. They have been forced by the public, man. They were forced by the public. Then they have on fair day admitted something, but then disclose our name. Also. I am the accused number 3, my lord. Here. Once Sonwar, he was arrested. And he was granted bail.
Can be granted.
Lordship, let them appear. Their statement will be recorded.
Heard learned counsel Mr. J. Ali,
Yeah,
J. Ahmed for the petitioner Hakim Ali, alias Baharul, Ali, who has filed this application under section 482 of the BNWS 2023 with prayer for pre-arrest bail, as he is apprehending arrest in connection with so-and-so PS case under so-and-so sections. The allegation against the petitioner is that he was named by two miscreants who were caught red-handed after committing theft from the informant's house. Full stop. It is submitted that the petitioner has been falsely implicated by two miscreants.
Case number 1 Sonora here.
Named in the FIR. The petitioner is willing to cooperate with the investigation and to abide by any stringent bail conditions if imposed upon him. It will kill any hard miss and thus. I already here. Humadi. Yeah. Hard miss and thus learning edition PP. So Likidia, I have considered the submission I have considered the submissions at the bar. Considering all aspects, it appears that interim bail will be granted to the petitioner. Call for the CD, list the matter on. In the event of this arrest, the petitioner shall be enlarged on bail of rupees 30,000 with a suitable security of like amount to the satisfaction of the arresting authority under the condition that the petitioner shall refrain from such activities with which he is alleged. Number 2, the petitioner shall appear before the IO within 1 week and cooperate with the investigation. Number 3, the petitioner shall appear before the IO on every fortnight till completion of investigation. And the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall automatically cancel.
Hello.
Item 6.
May be lodged.
Hmm.
But it's a 480 application lordship. FIR is a phase, my lord, 15 lordship. The Barnacle lordship. May I read the FIR lordship? সন্মানপূৰক বিনীত নিবেদন এৰিছে যোৱা ইংৰাজী 15/3/2025 তাৰিখে বিয়লি 5 বজাত 2 নম্বৰ পেটলিবাৰী গাঁৱৰ বিশ্বনাথ চাৰিআলি থানাৰ অন্তৰ্গত এজাহাৰকাৰীৰ মাটিত উক্ত পদকীয়াগণে মাটি দখল কৰাৰ উদ্দেশ্যত জেওৰা দি থকা অৱস্থাত এজাহাৰকাৰীৰ লগতে ককায়েক দেৱজিৎ দাস, ভায়েক ৰন্তু দাস আৰু খুৰাক ৰঞ্জিত দাসে মিলি সোধ-পোছ কৰাত উক্ত পদকীয়াগণে অশ্লীল ভাষাৰে গালি-গালাজ পাৰে। লগতে এজাহাৰকাৰী ও তেওঁৰ উক্ত ককায়েক, ভায়েক আৰু খুৰাকক প্ৰাণে মৰাৰ উদ্দেশ্যে আক্ৰমণ কৰি গুৰুতৰ জখম কৰে। গুৰুতৰ জখম প্ৰাপ্ত সকলৰ ভিতৰত এজাহাৰকাৰীৰ কাণ ফাটি কাণত 8টা চিলনি পৰে। হুলস্থুল শুনি কিছু সংখ্যক ওচৰ-চুবুৰীয়া উপস্থিত হোৱাত সৌভাগ্যক্ৰমে আমাৰ প্ৰাণ ৰক্ষা পৰে যদিও পদকীয়াগণে পলাই যোৱাৰ সময়ত চিঞৰি ভৱিষ্যতে আমাক প্ৰাণে মৰাৰো ভাবি দি যায়। This is the allegation against the petitioner lordship. And my lord, actually what happened lordship, the petitioner my lord, petitioner no lordship. Actual what is kindly see my lord the name of the accused person lordship. All 1, 2 and 3 number 3 lordship অজ্ঞাত 20-25 জন লোকে। That means my lord, if 27 persons attack 3-4 person lordship, whether they will survive my lord? Actually my lord, what happened my lord, informant and the petitioner shares the boundary land lordship. And on that day lordship, the petitioner engaged one labor to making some fencing lordship on the boundary lordship. When they received the information lordship, they came there, they came to the place of occurrence lordship. They have started to attack the petitioner lordship. Only some altercation took place lordship. Nothing has been done. Only
Have you lost the FIR?
lordship. My lord, we could not go there. They rushed to the police station lordship thereafter lordship with intention to harass us lordship. That's why we could not go there. Kindly allow me to participate in the investigation lordship. Kindly some protection may be granted. I will appear before the police lordship. At least my statement may be recorded lordship. Thereafter my lord, the actual fact will come out lordship. What is the actual fact lordship? Kindly see my lord that 3 persons 1, 2 and number 3 lordship অজ্ঞাত 20-25 জন লোকে attack lordship. Whether they will survive my lord. And due to some land
Call for the CD along with the injury report. Call for the CD along with the injury report of the victim.
only one
Injury report of the
no my
informant.
lord, 109 only 109 is non-bailable lordship. Otherwise so
Kanpati is head injury.
7th April. No?
List the matter on.
kindly give a short date lordship.
Yes, short date.
4th April.
4th April.
4th April.
Oblige.
Please, Lordship. For the application, Your Lordship. Offenses under section 64, Your Lordship. FIR vernacular person is page number 14.
Yes. Page number
14 your. Hanman
42?
Prove, Lordship,
FIR is at page number
14 your,
40.
1/4. Particular person.
Please read.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱাকালি প্ৰায় 8:30 PM বজাত উপৰোক্ত পদকীয়াই মোৰ লগত জোৰ-জবস্তি কৰি
সন্মানপূৰ্বক বিনীত নিবেদন এই যে ইংৰাজী 9/3/2025 তাৰিখে দিনৰ 2টামান বজাত মা ভাটাৰ মোৰ স্বামী ইজাজুল হক বয়স 27 ইয়াৰ্ছ ভাটাৰ কাম কৰা পাবলগীয়া টকা বিচৰাত উপৰোক্ত আসামীগণে তৰ্ক বিতৰ্ক কৰি মাৰপিট কৰি গুৰুতৰ জখম কৰে 2, 3 আৰু 4 নং আসামীয়ে মোৰ স্বামীক আগুচি ধৰে 1 নম্বৰ আসামীয়ে মোৰ স্বামীক প্ৰাণে মৰা হত্যা কৰাৰ উদ্দেশ্যে গাড়ীৰ পৰা চোকা অস্ত্ৰ উলিয়াই মোৰ স্বামীৰ বুকুত আঘাত কৰাত মোৰ স্বামীয়ে প্ৰাণ ৰক্ষাৰ বাবে চোকা অস্ত্ৰ হাতে ধৰাত হাতত আঘাত কৰি গুৰুতৰ জখম কৰে 1 নম্বৰ আৰু 2 নং আসামীয়ে লোহাৰ পাইপ দি পিঠিত মাৰপিট কৰি গুৰুতৰ জখম কৰে শৰীৰৰ বিভিন্ন স্থানত জখম কৰে So this is the allegation, Your Lordship. So, Lordship, I have been running the brick industry more than 10 years. So, Your Lordship, this informant's husband is also working in the same factory as Lordship. Because time and again he was, Your Lordship, warned because he brought some of the people out there, Your Lordship, and started playing gambling, Your Lordship. So he was cautioned on many occasions. It is not that the outstanding balance are there, Your Lordship, because regularly you have been paying the Your Lordship the bill, Your Lordship.
Serious record, Lordship.
Totally.
Yes, injuries there, Lordship.
We need the
But
CDA.
but
Punched
yet,
on his chest.
Lordship, regarding Your Lordship, the lethal weapons
Then he got injuries on his hand because that is
regarding lethal weapons, Your Lordship. So has he been attacked by Your
short
Lordship?
Short date.
These are all
understand.
owners of the big industry.
I understand.
Because the Eid is forthcoming, Your Lordship.
No, without the
I
CD,
need
it's
to-
difficult. We'll
Lordship,
just
I
get
need-
the CD and then we will consider your prayer. We will not go into the statements also.
I need to make the payment of the labor because big industry is now totally closed, Your Lordship.
Short date. Call for the CD along with the injury report of the victim. This the matter on 4th April.
Lordship, at least two persons may kindly be interim, Your Lordship. Otherwise, Your Lordship, Eid is forthcoming. Laborers are asking for payment, Your Lordship. Only one at least, Lordship, out of 4. Because all are family members, all are owners, Your Lordship. That's my only request, Your Lordship. Submission, respectful submission. Out of 4, Your Lordship, 1 or 2, Your Lordship. And let the others, Your Lordship, after appraisal of the case. If anything against me, Your Lordship, any serious injuries there, Your Lordship, certainly treat it. 326 attack, then had he been attacked, then why not he is in the hospital? And there is no delay mentioned indicated in the FIR also. Your Lordship. After 3 days, the FIR has been lost. Only 3 kilometers distance from the place of occurrence. Did he not
So
report
see Bulbul Haq, no, not
Bulbul-
Bulbul Haq,
Lordship?
not Bulbul Haq.
Lordship, Bulbul. Yes, Your Lordship. Except Bulbul Haq, others 3. 1, 3 and 4.
No, only one. He's an elderly person, only him. They all surrounded him, no?
Lordship,
Okay, only
Lordship.
one. Our learned counsel, Mr. A.A. Devan, no?
Devan.
For the petitioner Saijan, who have filed this application with prayer for pre-arrest bail as they are apprehending arrest in connection with so and so PS case under so and so sections. Third, Miss Endas, learned additional PP Assam. The allegation against the petitioners is that the petitioner number 1, 2, and 3 held the informant, whereas the petitioner number 4 thrust a knife into the chest of the tried to thrust a knife into the chest of the informant, but the informant held a knife and sustained defense wounds on his hand. It is submitted that the allegation against who is the owner of the brick
All are owner.
is submitted that the petitioners are the owners of the brick kill KIL and they were paying the wages, but the informant indulged in gambling in the this in premises, no?
Yes,
In the premises of the industry, which the petitioner tried to prevent, and this incident occurred, and as a result, and consequentially, this incident took place. Full stop. Consequentially, this incident took place. Full stop. To consider the Miss Endas Lihila, to consider the bail petition, CD is necessary. Call for the CD. Meanwhile, I have considered the age of the petitioner number 1. The case an elderly person. So interim bail is granted to the petitioner as he has pledged to cooperate with the remaining part of the investigation. Call for the CD, list the matter on eke date thako. Meanwhile, in the interim and in the event of his arrest, the petitioner number 1 shall be enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner number 1, Samsul Haq, shall appear before the IO within 1 week and cooperate with the investigation. Number 2, the petitioner shall refrain from such activities which he is alleged on breach of any of the bail conditions. His bail order shall stand automatically cancelled. The pre-arrest bail of the petitioner number 2, 3, and 4 will be considered after appraisal of the CD.
May I please? The 482 application lordship will come to the FIR lordship at page 15 lordship. Page 15 is the
Yes.
yes lordship. It is in English only lordship. I'm reading the FIR lordship. Respected
Page
sir.
15, there's no page 15 here.
Page 10 lordship.
Page 12.
10.
Page 10, okay.
Yes, lordship. I'm reading lordship.
Mm.
To the officer in charge, Sipazar Police Station, Dorong, so. Then, respected sir, I Hitesh Dega, son of Sindra Dega, so and so, resident of so and so, would like to formally lodge an FIR against the following individuals. These are the names lordship.
Mm.
And petitioner is the fourth number, serial number 4 lordship. The details of the incident lordship. On 1st of March at approximately 4 p.m. while I was standing in front of my residence, the aforementioned individual attacked me without any provocation. They assaulted me with a heavy iron rod, striking me on the head, causing severe and dangerous injuries. The entire incident has been captured on my CCTV camera as evidence. I am deeply distressed by the unprovoked act of violence and fear for my safety. I therefore request you to register this case against the accused person under relevant sections of.
Okay.
Lordship, out of these 4 lordship, already 3 has been granted interim bail by this court lordship.
Granted bail.
Yes, lordship, I have annexed that order. Lordship.
Yes.
Me. I have
No
not.
lordship.
No
Other
lordship.
the last page lordship.
Page 13 lord. Justice PJ Shukla.
He's out of station, no?
Yes. He also may be granted.
Honey.
Wait, please, Your Lordship. But in this case, I am led by my senior counsel who is on VC, Mlad.
Arunachal Pradesh's case.
Alright.
Case from which place? State of Arunachal Pradesh. and
Yes,
others?
Mlad, that case was
What has
filed.
come up here?
Mlad, in
Yes,
fact,
Not in Itanagar?
Mlad, they have filed earlier, Mlad.
Originally, during the COVID period, Lordship, after taking the permission from the Honorable Chief Justice, Lordship, it was filed before this Honorable Court. And Lordship may see the last order.
Ladyship will see nothing survives. If the ladyship sees the last order of 24th February 2025 of Justice Saikia Millard, if I can place that order, because the FIR is quest, and that is why Justice Saikia records Millard. If I can read the 24th February 2025 order.
You are for the petitioner?
Respondent number 2 and 3, Mlad. I'm led by
accused.
Mr. Lahoti.
Okay. So,
Lordship, the leading counsel in this case is Mr. Dushan Verma. I'm the local counsel here. Yeah, I have already communicated with Mr. Verma. I have sent notice to the daughter of the present petitioner because the present petitioner has expired. So I have not received any response, Lordship, and Mr. Verma has already instructed me not to appear in the matter. So on my instruction, on my part, I have no instruction. I send a notice to the both, there are two.
Just a moment, just a moment. এই ভলিউমটো অলপ বঢ়াই দিব লাগিব মই শুনা নাই ভালকে এই নহয় এখেতক মই ভালকে শুনা নাই ভিডিঅ' কনফাৰেন্সিঙৰ কি কৈছে
If I
Lordship,
can,
there are two available addresses with me with regard to the addresses of the daughter of the present petitioner, Lordship. He, in fact, she signed the affidavit in the present petition because probably
who
because
has passed away
the petitioner himself, Lordship.
oh
Lordship, in the meantime, we made a prayer before this honorable court for substitution. But in the meantime, this FIR in the Itanagar bench, the FIR got passed, Lordship. It is on
Oh.
record.
this
So
this
nothing
entire
survives, in fact.
recording,
So,
if I can,
yes
what I was submitting, the ladyship will kindly appreciate the order of 24th February 2025. That order of Justice Parthojyoti Saikia records everything. And if I can place that order, para 2, this application has been filed praying for setting aside an order granting an anticipatory bail by this court in respect of FIR 8 of 2021 registered by Choham, Arunachal Pradesh. Mr. Lahoti, me, learned senior counsel for the respondent, has pointed out that wide order of 25/9/2024, Arunachal bench of this court had quashed the said FIR. Now, this is important. According to Mr. Lahoti, nothing survives now. Mr. Das, learned counsel for petitioner, submit that the original petitioner has expired and in his place his daughter was supposed to be substituted. According to Mr. Das, learned counsel for the petitioner, he has lost contact with the legal heir and the original petitioner. According to Mr. Das, the petitioner was originally represented by Mr. D. Verma. He also submit that he has lost contact with Mr. Verma. After hearing the learned counsel for both the sides, now this is the most important part. This court is of opinion that nothing survives now since the FIR has already been quashed. However, since the petitioner Das prays for some time to make contact with his client, therefore this court is of opinion that it should be given one opportunity to that effect. Now the ladyship had seen the FIR itself is being quashed on 25/9/2024. When FIR is quashed, already mirrored, nothing survives. And that has been recorded by Justice Saikia on 24th February order. An
already
opportunity.
recorded
Yes,
And,
already recorded.
on top of that,
And my learned friend was given the opportunity so that he can contact the clients. Now he makes a statement, if I rightly understood, that he had tried, but he is not able to contact the clients. Neither the counsel was leading him also, is in touch with him, or this is the situation. So the last opportunity which was given, and since nothing survives, it need to be mirrored, closed or disposed of.
in fact, on the last, on 24/2/25 itself, Lordship, the leading counsel has instructed me after the case was over, he sent a message, no need to appear.
So that can be recorded, my lord, and lordship may close the matter.
Third learned counsel Mr. D. Das, no? For the petitioner, Mio Lihiriba, Namtu, who has filed this application under section 439.
Lordship.
482, my lord.
Read to section 439 of the CRPC for cancellation of
482, my lord.
It is 482.
482 read with
482 read
section
with
439 of the CRPC for cancellation of anticipatory bail granted to the petitioner by the learned session judge East Division Teju in connection with so-and-so
FIR
case
number
under
8. FIR number 8 of 2021.
so-and-so case under so-and-so sections. It is heard learned senior advocate Mr.
ML Lahoti.
Mr. Lahoti, no?
Yes, my lord.
Grateful.
Learned counsel Mr.
Dubey, R. Dubey, my lord, I am
R.
assisting. my lord.
R. Dubey. For which respondent?
Respondent number 2 and 3.
Respondent number 2 and 3 and Learned
I'm for the respondent of 5.
respondent number
1.
1. S, oh, okay, PP. Learned Public Prosecutor, Mr.
A. Chandran.
K. Chandran.
A. Chandran.
A. Chandran for the state of Arunachal Pradesh. It is submitted that the FIR number 8 of 2021 has already been quashed and it has been held by this court by the order dated 24/2/2025 that as the FIR has already been quashed, nothing survives now. More so when the petitioner has passed away. The petitioner's legal heirs also could not be traced out.
One thing, Lordship. Here, the daughter of the petitioner, Lordship, she had already approached the Itanagar bench. And that is the same FIR. That was also become as being infraction. This is the order.
The Learned PV Arunachal Pradesh has submitted that the petitioner's daughter.
No, sir.
What was your submission? What did you say?
Lordship, the petitioner's daughter has already was the Itanagar bench. As because the FIR has been called, that petition has been withdrawn.
The petitioner's daughter stroke legal heir has already approached the Itanagar bench and has withdrawn the what has she withdrawn?
Lordship, as the FIR has been caused in the earlier occasion, Lordship, so this matter has been infracted.
So that is a separate case, my lord, may not, my lord,
Not required.
not required. Only your lordship can say that, my lord, the daughter of the petitioner also has notice of this case, my lord. Still, my lord, nobody has come, and my lord, your lordship can record my learned friend's statement that the engaged counsel has informed him not to appear. But because for my friend only, my lordship, you had granted opportunity last occasion, my lord. He said that otherwise he would be in difficulty. So, my lord, he has got instructions not to appear, my lord. And nothing survives in the case, so that will seal the matter.
This is not required not to appear. Why is it? So I don't think.
No, he has instructions, otherwise, that's why, my lord, he has.
Learned counsel Mr. D. Das has submitted that engaged counsel Mr. D. Verma, senior counsel.
No, not senior.
Engaged counsel Mr. D. Verma.
He's the leading counsel.
Leading counsel Mr. D. Verma has advised the learned counsel Mr. D. Das not to
Appear in
this case. As the matter has become infructuous, matter stands closed.
Grateful.
I'll try to include this, but I'm not getting your point. I'll try to include this. I'll come back after 5 minutes.
Wait, please, your lordship. Before starting, lordship, may I submit lordship? Here, in this case, lordship, CD was updated. CD was called for lordship. We have the CD lordship, but it is not updated lordship. Some instructions are sought for from the government institutions lordship. Those are yet to be received lordship. So lordship may kindly fix the matter after due vacation. In the meantime, we will receive that.
Learned counsel Mr.
DK Boydra.
DK Bodde is present for the petitioner. Learned counsel, learned additional PP Mr. PS Locker has submitted that. But what
Some instructions are yet to be received from the government institution, and those are after receipt of the receipt.
that he will obtain instruction from the government institution, list the matter on. Okay.
Lordship, the interim order passed earlier, maybe nothing.
Interim order shall remain in force till then.
My lord, deeply obliged.
Actually, senior.
Lordship, other people may be granted. Actually, Lordship, recently, Punjab and Haryana High Court, Lordship, in its ruling, a batch, Lordship, neutral citation, 2024, PHHC 076452 DB, Lordship. They've stated that there is no bar, but our no bar in Lordship.
Oh, yes, yes, I know, I
Yes.
know. There other high courts are there, but
Yes,
here in this high court, there are conflicting
yes,
decisions.
yes. So Lordship,
Somebody
other
agrees and
maybe-
somebody disagrees, but
So-
the matter was before the Supreme Court, I don't know.
Yes, yes, it's still
Not disposed.
Not disposed of.
Lordship, the other may be given, other than Hakizul and Tomizul.
No, no, these two are,
Yes,
they
these
cannot
two
be
not be
granted.
given, other may be granted, not the people.
Let me see if I can grant them bail.
Yes, sir.
Only thing is that assault part is there, Lordship. That's why.
But Lordship, assault only for eating, Lordship.
So for 498A,
Mm.
at this I am not going to argue because it appears there may be some materials for having it. So for 406,
Mm.
I go to the extent to say that 406 is absolutely false claim. I need not argue anything except showing their own evidence. It is a complaint case. They were husband and wife.
Mm.
The wife left the house.
Given your submission,
Yes.
yes, yes. Petroleum ekhon diba, huh? Yes, what do you have to say?
First of all, my lord, my submission is that, my lord, the case was, my lord, investigated by a person, my lord. He is a, my lord, assistant ASI, my lord, assistant sub inspector, my lord. And so far the rule is concerned, my lord, it says, my lord, not below the rank of an inspector.
Not below the rank of.
Not below the rank of inspector, my lord. That
Rule
is-
198, no?
198, yes, my lord, exactly, my lord. 198D, my lord,
198D, no?
D. The table, my lord,
Not
198.
below rank of inspector.
Yes, my lord. And suppose, my lord, if a police also, my lord,
Mm.
even if he, my lord, assuming, my lord, an inspector seizes this product, my lord, like, he has to immediately, my lord, then 198(2), my lord.
Mm.
It says, my lord, he shall forthwith report the fact by telegram to the chief controller and controller having jurisdiction over the place. So in the instant case, my lord, in Guwahati, we had the, my lord, joint chief controller of explosive, Chandmari, Guwahati. That was not
198.2, no?
198(2). Well, I don't have the diary, my lord. I think the diary, whether it reveals, my lord, whether he had communicated the same to the joint chief controller of explosive, Chandmari, Guwahati or not.
Joint chief controller of?
The joint chief controller of explosive. And then the joint chief controller of explosive, my lord, will take out a sample, my lord, and the same should be sent to the testing officer.
Yes, yes, this is usually done.
Yes,
From
my
the
lord.
truck, they are taking
Yes,
out
my lord.
samples.
And the testing officer is appointed as per section 26. So it is not FSL. And the first and the foremost submission is that, my lord, no license is required as per section 7. And in the 198 itself says, my lord, what they can seize, my lord. Seize detail, my lord.
Section, what was the section? This is required?
Testing officer,
Ah.
section,
No, no, section, no licenses required.
section 7.
Section 7.
Section 7.
Yes.
Now, my lord, in the 198D, my lord, what they can seize, my lord. Seize, detain, remove any petroleum or any petroleum suspected to be petroleum or any equipment or appliances, not the vehicle also.
Yes.
And my submission is that, my lord, page 22, my lord, I have purchased the same from a farm in, from a company in, from, in my lord, Sikkim, Gangtok, my lord. After paying, my lord, the necessary, my lord, GST, page 22.
All
That,
right.
that my submission, my lord, PP one.
Yes, what do you have to say?
My lord, here I have, my lord, come to the CD and also, my lord, the act, my lord. My lord, here the act is, my lord, Petroleum Act, my lord. Here, my lord, chapter 1, my lord. The rules for import, transport and storage of petroleum, my lord. I'm not going to details, my lord.
Right. Chapter one.
Petroleum Act, Petroleum Act. And chapter 2 is, my lord, testing of petroleum, my lord. Regarding the testing part, my lord, as because, my lord, related to petrol and petroleum products, my lord, two classes are there. So, my lord, there is authority of testing is different, but my learned senior has stated. Now, my lord, here, my lord, two sets of rules are there arising out of the same Petroleum Act. One is, my lord, the Petroleum Rules 1976, my lord. But my learned senior has submitted, my lord, from 198A powers to enter, inspect, search and seize, my lord. And there, my lord, the officers, who are the, my lord, the power conferred on which officer, that is given. And regarding the police, it is stated as the rank not below the rank of inspector. Admitted fact. Now, my lord, there is another rules, my lord, the Petroleum Rules 2002, my lord. These rules, my lord, there it deals with part 4 transport on land by vehicle, even the license, who can transfer, and what should be the measures taken during the transfer and how it can be done. Now, my lord, in the 2002 rules, my lord, it is the part 2, that is the general provisions. There in rule 3, my lord, it is restriction on delivery and dispatch of petroleum. No person shall deliver, dispatch any petroleum to anyone in India or other. So this type of things are there. Now, my lord, here from the diary, my lord, and from the report, my lord, as earlier date, my lord, I have submitted the report, my lord. It is stated that, my lord, the FSL report regarding that part is not, my lord, procured by police. Meaning thereby, my lord, that is the police is not able to understand the exact nature of petroleum product. Secondly, my lord, that is the GST and the other, my lord, documents which enclosed with the petition. It is stated that, my lord, it is the paint, my lord, called paint thinner, my lord. And paint thinner is, my lord, it is a kind of explosive also, my lord. Some cases, my lord, and studies regarding that part is also, my lord, available by various, my lord, research agencies. Now, my lord, going through the CD, my lord, may kindly peruse, my lord. The last part only I am stating the horizontal part, my lord. My lord, here, my lord, another section is also added. ECA. নতুন নতুন এক কৰিছে মই কথাটো কৈছো ECA, my lord, horizontally flag mark, my lord, last part, my lord.
Yes.
And my lord, going through the CD, I have come to know, my lord, regarding the testing part, my lord. Regarding testing part, my lord, they are not going by this Petroleum Act because I didn't get it, my lord, and clearly stated, my lord, that part also I have flag mark that they have sent it for FSL, my lord. FSL. So, my lord, that is the fact. Only my lord, humble submission before your lordship is there, my lord, as because, my lord, the nature of the, my lord, product is explosive in nature, my lord. So, my lord, may kindly direct, my lord, to take the testing report from the proper authority concerned, as stated by my learned senior, and thereafter, my lord, getting that, my lord, if this court is satisfied with all the documents That is they are the my lord who has purchased those things in proper channel, my lord, as per the rule, my lord. Then, my lord, as per my lord, that they can, my lord, that can be, my lord, given. Because otherwise, my lord, it is the section 23 of the Petroleum Act for the, my lord, penalties, and section 24 for the confiscation. My lord.
But this is under revision. It has come for revision, no? Revision, yes. So can I interfere with the investigation? Direct them to go for FSL and all, or to go for testing through?
My lord, that is also a part. But my lord, only thing is that, my lord, here only I'm on the, my lord, exact nature of the product, my lord. My lord, who will, my lord, say that this is that product, my lord? Testing officer.
Section 26.
Yes.
It
But
will
that
be
was not done because, my lord,
It will be
from-
mentioned in the order, and then they can, from the order, whatever they will learn, and then, but direction, I don't think so. I'll be able to. I have only to find out the impropriety of the order.
Then your lordship will interfere with the investigation.
Propriety of the order.
76, that my land says 76 rule, my lord, that has been repealed, my lord.
76 rule.
76 rule repealed, my lord. My lord, petroleum rules 2002, my lord. Rule 202, my lord.
Yes, inspector.
Rule 202, my lord, of petroleum rules 2002, my lord. The petroleum rules 1976 are hereby repealed.
Ready to put.
Inspector, Act of Section 26.
It's okay.
2002, no?
2002. my lord.
Rules 2002.
Rule 2002, Rule 202. Repeal.
Petroleum rules 1976 repeal.
Repeal. That's what you have to make. Ultimately, my lord, if they file a charge sheet also in this case, my lord, it will vitiate the trial because he is not authorized. My lord, I have made my submission, my lord. One case law, my lord. I had a soft copy. I will give a hard copy to your lordship. Recent judgment of the apex court.
I'll need some time, I think. CAV.
But within an hour, I'll submit.
Okay.
Court must.
Order আছে নে admission আছে?
Admission.
Admission আছে না? CAV করে order করলে time.
I'm up there.
Oh, city gon লাগিব delivery order কৰিব লাগিব. I'll have to fix it for order because I'll retain the CD for a few
My lord,
days.
my lord, may retain it, my lord.
Hey, a petrol mech on to diba?
My lord, may kindly fix a date then.
It won't be more than 10 days. Okay. Delivery of
Yes, madam.
order, it won't take more than 10 days.
Okay.
Item 15, bail hearing.
Kindly pass over the matter.
For time being?
Timing.
All right.
Item 16,
Lordship, in this case, my submission is that accused person arrested on 30/12/2024. Today is 85 days. Lordship. Kindly, Lordship, consider the length.
You have the CD? Where's the FI?
Well, Lordship, at page 9, Lordship. Type copy. May I read it? The humble submission of informant is that on 22/11/2024 at about 7 p.m., the accused number 1 called my mother, namely Hanufa Khatun, at their house to show the guys who were playing game in mobile phone. And after that, the accused number 2, who heated iron rod in their fire head and stabbed at the stomach of my mother and injured her seriously. Accused number 2 also assaulted my mother in her head with rod. My mother still going treatment at GMCH. Therefore, you are requested to investigate.
So
the
this
matter.
patient is alive or she died?
Died, Lordship. Earlier occasion, Lordship has gone for the case, the eyewitness, there, everything is there, Lordship, but FSL report is not received yet, Lordship.
Okay.
But she was brutally killed by the petitioner, Lordship. It was eyewitnesses, everybody is in the eyesight, Lordship.
Lordship, I'm not married on the case, Lordship, but 85 days today, Lordship.
Only waiting for the FSL report, otherwise,
That CD, did you send back the CD?
we have not written the city call for the FSL report,
Uh,
only for.
so we asked you to send back the CD. You have sent it back. no?
Yes, not, they were not taken back.
Oh.
Today is 78 days. One din? 85 days.
32.
Oh, 85 days today is. 25.
85 days.
85 days. Pending case. Only on the considering the length of the otherwise sufficient materials are there against the petitioner.
I'm on the mail.
She was hitting the iron rod and when she, well, disease entered the premises, she took the rod and brutally stabbed with the rod.
Let me see.
I have like murder statement.
The CD is with us, then how will they submit charge sheet? They are not taking back the CD. Why they are not taking back the CD?
Unable to submit the charge sheet.
At least they could take back the CD, you know.
Yes, sir, I have communicated with the IO.
Postmortem report?
Earlier one. In the earlier pages.
26 centimeter inches wound.
Hot iron rod. So it's just pre-planned.
There's another 2 centimeter into 3 centimeter. On the stomach. With 2 stitches. Left forearm are bandage, chest, right upper chest bandage, needle puncture wounds in left forearm and right upper chest beneath the bandages. This lady, I'm not granting bail.
Brutally murdered.
Huh?
Brutally murdered.
This man may be granted bail.
I am for the
Kimanda, sir. That lady.
You're only for a lady.
Lady Lordship.
That man, no.
No,
Only one petitioner here, Lordship.
Oh,
That lady.
kindly consider the letter.
no.
Lordship, she is suffering from mental disorder.
Hmm?
And Lordship kindly fix it, 28, on 28, I am, she is suffering from mental disorder, this lady, Lord.
Then we will send back the CD and call for the CD.
On 30th, Lordship, mandatory.
It's from the
period of-
Kamrup only. We'll send it back.
Nagar Bra, Lordship.
Ask them to send it back.
Look.
Then Lordship on 28th,
You'll submit an additional affidavit.
no, Lordship, there are some documents regarding. her
Learned
mental
counsel
health.
for the petitioner, Miss
P. Kolita, Lordship.
P. Kolta has submitted that she will submit some documents relating to the mental health of the petitioner. Send back the CD, call for the up-to-date CD. Whatever they give, we don't want any report or anything. Okay? So postmortem report is sufficient.
Sufficient, Lordship.
List the matter on, that will be 28. Beyond 28, it will be 5 days. Then it will be over, 5 days will be over.
Lordship, on 30th,
28, yes.
apply.
Item 17.
Mm.
Regular bail application, my lord, in connection with Mazuli PS case number 1 of the 25, my lord, under section 103, my lord.
Mm.
Earlier, it was rejected by the session judge due to non-partisan autopsy report, my lord. But his honorable court also, while the
This,
the matter, it was not
received
reports, my lord.
It's one, no poison and its metabolics were detected in the exhibit. Lordship.
79 days in the jail hospital already.
And number 2, Lordship. It gave positive test for ethyl alcohol and its amount was estimated as 0.1703%. 0.1703 gram of ethyl alcohol was present per 100 ml blood sample. So his alcoholic mood he was on.
In a
The
picnic,
suicide or death?
So that he after picnic when doing
Murder,
the
suicide.
allegation is murder, Lordship. After going
What is the report? PM
report, his PM report is
antemortem or postmortem?
postmortem
my
report.
lord, while they are enjoying picnic, my lord, he received a phone call and going to the steep of the river, Brahmaputra River in Oklamuk Ferryghat near Majuli, and fell down in the river.
They were,
Others all are colleagues. I am for one petition, one accused person.
as per the statement, Lordship, they enjoying the picnic, suddenly he was missing from the picnic spot, big group. And his body was recovered after 7 days in the Brahmaputra River, Lordship.
I have rejected the bail earlier.
No, session court.
Session court
Oh,
rejected,
sessions
my
court.
lord, due to non-furnishing of autopsy report.
Lordship is waiting for the FSL report.
And my lord, this court also fixed earlier, my lord, 12/3 fixed today for the autopsy report.
Yes.
This court fixed today for the autopsy report, my
That FSL report, Lordship. Alcohol was found in his body, Lordship.
already 79 days.
Let me see the FSL report and the postmortem report.
Lordship.
Where is the FIR?
FIR page 24.
20?
24.
in Bharnikul. May I read the FI?
Yes, please read the FI.
মহোদয় সন্মান সহকাৰে আপোনাক জনাও যে মোৰ ভতিজা পিংকু হাজৰিকা আটাইকেইজনৰ পৰিয়ালৰ লগত বহু দিনৰ চিনাকি হয়। যোৱা ইংৰাজী 29/12/2024 তাৰিখৰ পৰা আটাইকেইজন পদকীয়াই পিকনিক খাবৰ কাৰণে পিংকু হাজৰিকাক ফোন কৰি মাতি আছিল। সেইমতে আজি ইংৰাজী 30/12/2024 তাৰিখে পিংকু হাজৰিকাৰ ভায়েক ককায়েক শ্ৰী পল হাজৰিকাই টমটম গাড়ীৰে পিংকু হাজৰিকাক হাজৰিকাৰ দুপৰীয়া 12 মান বজাত অকলামুখ 3 নম্বৰ স্পাৰৰ ওচৰত পদকীয়াজনৰ ওচৰত চমজাই থৈ যায়। পদকীয়াজনে ভাত খোৱাৰ পাছত পিংকু হাজৰিকাক লৈ যাবলৈ পল হাজৰিকালৈ ফোন কৰাৰ কথা কয়। আবেলি 4 বজাত শ্ৰী প্ৰশান্ত বৰুৱাই শ্ৰী পল হাজৰিকাক ইজ দ্য ব্ৰাদাৰ অফ পিংকু হাজৰিকা পল হাজৰিকাক ফোন কৰি জনায় যে শ্ৰী পিংকু হাজৰিকাক বিচাৰি পোৱা নাই আৰু সোনকালে মাতে। তেতিয়াৰ পৰা পিংকু হাজৰিকাই বিচাৰি পোৱা নাই। পিংকু হাজৰিকাৰ চেণ্ডেলযোৰ পাছত এখন নাৱত পোৱা যায়। আমাৰ সন্দেহ হয় পদকীয়াজনে পিংকু হাজৰিকাক কিবা অঘটন ঘটাইছে। আমাৰ সন্দেহ হয় কিবা অঘটন ঘটাইছে। গতিকে মহোদয়ক দয়া কৰি বিহিত ব্যৱস্থাৰ বাবে অনুৰোধ জনালো। But they have registered a case under section 103 in BNC. And there is no any eyewitness or no any evidence.
Heard Mr.
Krishna is a BA student also.
What is your name?
D. Bora.
Heard Mr. D. Bora, learned counsel for the petitioner Biswajit Hazarika
Soikia.
Biswajit Soikia, who has filed this application under section 483 of the BNWS 2023 with prayer for bail, as the petitioner is behind bars since
5/1.
5/1/2025
79 days.
with so-and-so PS case under so-and-so sections. Heard Mr. D.P. Goswami, learned additional PP Assam. I have scrutinized the case diary, the FSL and the FSL report. I've considered the submissions at the bar. The FIR against the petitioner is that the allegation against the petitioner is that
There were altogether
that
6.
the petitioner, along with the deceased and other co-accused, namely the FIR, went out for a picnic, but the deceased Pinku Hazarika was found missing. Pinku Hazarika, no?
Pink Hazarika.
Pinky Hazarika was found missing. A frantic search was made, and finally, the body of Pinku Hazarika was recovered from the
River Brahmaputra.
from the river. Full stop. Investigation has progressed substantially. The merits of this case are not brought to the fore as investigation is still under progress. I have also considered the length of detention. It appears that bail may be granted to the petitioner. Stop. The petitioner has pledged to cooperate with the remaining part of the investigation and to abide by any stringent bail conditions if imposed upon him. Considering all aspects, petition is allowed. The petitioner is enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of.
My lord, surety amount, my lord.
This will be CGM Kamrup, CGM Majuli.
CGM Majuli.
To the satisfaction of the CGM Majuli under the condition that the petitioner shall cooperate with the remaining part of the investigation and appear before the IO on every fortnight till completion of investigation. Number 2, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall stand automatically. The learned court is at liberty to cancel the bail granted to the petitioner, send back the CD.
My lord, Majuli PS case number 1/25 and subsequent GR case, my lord, 02/25.
Item 18.
My lord, bail amount rupees 20,000.
50,000 call negi? 50.
My lord, it will be more, my lord. They are very poor persons, my lord. Kindly.
20,000 koi diye. 20,000.
Oblige, ma'am.
Right, please.
Mm.
Well, it's a regular bail application, my lord, under 483 of the BNSS, my lord. Yeah, my lord, under the NDPS Act, my lord, and
Grounds of arrest
not for any, that is, and prolonging.
Let us see. Let us see the grounds of arrest.
My lord, that we have tagged my lord in that file, my lord, LCR, my lord. Lordship has seen the additional affidavit possibly.
I have not seen the LCR. No, now everybody is taking the plea of grounds of arrest.
That we have taken now, my lord, in the additional.
Once a plea is taken, that this keeps on getting repeated.
My lord,
Where have you seen the grounds of arrest?
Yes, that's right.
50 CPC, 50
Lordship.
CRPC, flag mark
Like my lord.
in the LCR.
LCR.
LCR. The pink flag, my lord.
Arrest memo 50 C.
And lordship has a earlier order also there. Lordship.
This is-
Then you will submit reply or not?
Regarding
My lord, coordinate.
You are in the jail for how many
No,
days?
that is 2 years, 5 months,
Huh?
2 years, 4 months and 26
Any
days.
witness have been examined?
Only one, my lord. Lordship,
Out of how many witnesses?
8, my lord.
You submit reply relating to grounds of arrest.
Here already possibly.
Because you see here, this case is contested case. Police has submitted that they have given grounds of arrest to the wife, so and so and so and so. Let a lot of submissions. So you submit reply.
My lord, kindly see the, my lord, with all respect, my lord. Is possibly, my lord, already settled because 3 coordinate benches, my lord, on the same count, my lord, and in ND special act itself, this act itself. my lord.
Yes, I know.
It was that 3 orders we have annexed, my lord. Lordship passed down to, my lord,
Let us give them a time to submit a reply on the
but,
grounds
my
of
lord,
arrest.
in all those cases also, the submissions were made, my lord, and it was negated.
They were conceding to the judgment
No,
of
no,
the
no,
Supreme Court.
they made their replies, they have objected, they have stated 37 bar is there. But because of the Vivan case, my lord,
No, but in this case, they have prosecution has actively submitted reply.
which,
It is PMLA case, Bihan's case.
yes, my lord.
Bihan's case.
But ultimately, the law laid down was that, my lord, it has to be there, my lord, and that too in
A
writing. my lord.
verbal is also enough.
No, my lord, with my, I may be wrong, my lord, because,
Paragraph 26.
but yes, but Purkasta, my lord, Purkasta makes this clear, my lord,
Let them submit whatever they have to say.
and prolonged delay, because if your lordship
No, we'll give them an opportunity on grounds of
That is
arrest.
true, my lord. If your lordship consider the length of detention, that prolonged incarceration also, my lord, because lordship earlier order, my lord, that would also lordship see, my lord. Lordship stated that it should be done expeditiously, my lord. In spite of that, my lord.
No, but these grounds of arrest, it's something very strong and
Yes, that
very
is-
new, yes. So we'll let them submit reply. We'll give them some time.
Madam.
Learned Counsel Mr. A. Chaudhary is present for the petitioner. Learned Additional PP Mr. D.P. Goswami has submitted that he will submit a reply. He will file an objection relating to the bail petition. List the matter on 9th April,
Lordship,
or you want an earlier date?
if possible, little bit, my lord.
So much time is not required. One
that is-
judgment, not very long judgment.
And all, if lordship doesn't take a different view, all the three judgment, my lord, short, my lord, considering the other two,
I may not take a different view.
my lord.
I may not take a different view. Let them submit a reply.
That, if your lordship doesn't
That
take a different.
allowed your bail
Yes,
petition
yes,
on
yes,
grounds
yes,
of
I'm
arrest.
always obliged, my lord. What I mean, my lord, those judgments are short. So, my lord.
You elaborately
It is,
took me through all the paragraphs.
Yes, yes.
Paragraph 26 also, I
Yes.
remember.
Yes,
So
yes.
I may not take a different view.
Yes, but no, if I stated, my lord, then it will take some more time
Yes.
to write, my lord. That's fine. Obliged, my lord.
No, he won't take this. Oh, I read in one night, I read the judgment.
Yes, yes.
It did not take me much time.
Yes,
Then I found some points also.
my lord.
Found some points also. So we can read between the lines also.
Gotcha, my lord.
I may not take a different view.
My lord. Obliged.
No, 7 please.
Grounds of arrest.
My lord.
So he'll file a
No,
file
grounds
an
of arrest
objection.
My lord,
On grounds of
I-
arrest, NDPS,
no, my lord,
not NDPS.
not NDPS.
Because you usually come with NDPS cases.
My lord, I was arrested on here, in fact, my lord, 24th of December, my lord.
Mm.
Now, my lord, today, my lord, fortunately or unfortunately, my lord, today I am 90 days behind the bar, my lord.
Mm.
4 December or 25th December. So, my lord, mandatory period may be considered as.
You have the CD?
Yes, lordship.
We'll have to consider mandatory period.
Man-
SARSI not submitted.
Not submitted.
So-
CD is here, lordship.
Hmm?
CD is here.
No point. SARSI is not submitted, no point. Our learned counsel, Mr. N.K. Marino,
Yes, lord.
for the petitioners 1 to Soyazon, who have filed his application under section 483 of the BNWS 2023 with prayer for bail as they are behind bars since 24/12/2024 in connection with 24, then it will be 90 days, no?
How many days? 91 days, no?
It will be 90 days. In connection with so-and-so PS case under so-and-so sections. Heard Mr. D.P. Goswami learned an additional PP Assam. It is submitted that CDs is received, but charge has not been submitted against the petitioners. Who stop? All the petitioners are behind bars for 91 days, no? 90 days or 91 days?
90 days, my lord.
Have you calculated the 2 days less in February month? 28,
Yes,
huh?
yes,
You
my
have
lord.
calculated.
91 days.
Behind bars for 91 days. It is submitted at the bar that the statutory period has already elapsed. Stop. I have considered the length of detention. The petitioners are thereby enlarged on bail of rupees 50,000 each with a suitable surety of like amount to the satisfaction of the
Additional CGM Karbi Alambai.
CGM. It will be CGM only.
Whatever, my
Learned CGM Karbi Anglong. Send back the CD.
my lord, just one request, my lord. Other co-accused, my lord, this speaks on 20th Friday, my lord. CD may kindly be written till 10.
No.
My lord,
Send back the CD. No.
Lord, Lordship, co-accused already, my lord, fixed matter is there.
No. We
CD
cannot keep 103 case pending. We cannot keep CDs for so many days. We'll send back the CD.
Oblige, my lord.
Made. CD was called for.
It is received.
But So we'll find the FIR case 17, madam. 17, vernacular.
Please read the FIR.
Yes. মহোদয় বিনীত নিবেদন এই যে যোৱাকালি নিশা অনুমান 12টাৰ পৰা এটা তাৰিখৰ ভিতৰত মোৰ হোৱা কোঠালিৰ দৰ্জা চুৰি নিজ কুশলত ব্যৱস্থা প্ৰয়োগ কৰি দৰ্জা ভাঙি ভিতৰত প্ৰৱেশ কৰে আৰু ভিতৰৰ আলমাৰি খুলি নিম্ন বৰ্ণিত বস্তু বাহিনী চুৰি কৰি নিয়ে। হঠাৎ মোৰ প্ৰস্ৰাৱ লগাত বা সাৰ পাই কোঠালিৰ ভিতৰত বিশৃংখল অৱস্থা দেখি বিচনাৰ পৰা জঁপিয়াই নামি তলত আহি তলৰ প্ৰৱেশ দ্বাৰত গ্ৰিলৰ তলা ভঙা আৰু দৰ্জা খোলা দেখি তৎক্ষণাৎ ওপৰত আহি দেউতাকক মাতো আৰু উভয়ে তলত নামি কম্পাউণ্ডটো পৰ্যবেক্ষণ কৰোঁ। বাহিৰত কাকো নিদেখি প্ৰতিবেশী মোৰ দাদা এজনক মাতি আমি তিনিওজনে মূল গেট খুলি কম্পাউণ্ডৰ পৰা বাহিৰলৈ আহি অলপ পৰ্যবেক্ষণ কৰি লগে লগে ভগদত্তপুৰ আৰক্ষী আউটপোষ্টত হাজিৰ হৈ উপস্থিত কৰ্মৰত বিষয়াক খবৰটো জনাওঁ আৰু কৰ্মৰত থকা আৰক্ষী বিষয়াজনে লগে লগে পুলিচ পেট্ৰলিং প্ৰাৰ্থীক খবৰটো জনোৱাত পেট্ৰলিং পাৰ্টি গটিয়াৰ পৰা আহি আমাৰ দিশে গৈ আছে বুলি জনাত আমি লগে লগে আহোঁ। কৰ্মৰত পুলিচ পেট্ৰলিঙে পাৰ্টিয়ে আমাক ঘৰৰ দুৱাৰ মুখতে পাই আমাৰ নঙালৰ পৰা ভিতৰত প্ৰৱেশ কৰে আৰু সৰজমিন তদন্ত কৰি চোৰে এৰি থৈ যোৱা এযোৰ হাৱাই চেণ্ডেল এযোৰ সন্দেহজনক খুন্তি এখন আৰু তলৰ গ্ৰিল ভঙা তলাটো লগত লৈ যায় আৰু লগতে আমাক নীতিগত এজাহাৰ এখন দাখিল কৰাৰ পৰামৰ্শ দিয়ে। Some articles was stolen along with some debit card.
So what do you have?
But if he, the CSP owner, the
Yes.
petitioner, from his the brother-in-law of the main accused, lordship, one who was involved in that incident, lordship, he received 3,79,000 from that the main accused, lordship. But he has yet to be arrested, lordship, who was involved dealing with theft, lordship. His brother-in-law received the amount of 1,29,000 from this petitioner, from his CSP owner. He's a CSP owner. So
CSP, what is the meaning of CSP?
customer service point.
Oh, that State Bank, ATM.
Not
No, no.
ATM, it's a CSP counter as there.
Yes,
They have
of course, SBI.
SBI. Yes,
SBI.
Bandhan Bank here, madam. I am the CSP holder.
Where
The
the
accused Anwar
How
Hussain,
many days you are behind bars?
18 days, madam. 18
Okay
days.
then, okay.
main
Hard
accused,
learned
main accused yet to be arrested, lordship.
Yeah, I understand.
And
Hard learned counsel,
R.
Mr.
R. Islam.
R. Islam for the petitioner. Sujab Ali, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as the petitioner is behind bars since 26/2/2025 in connection with so and so PS case under so and so sections. Heard Mr. DP Goswami learned additional PP Assam. The FIR unfolds that on the fateful night, on the intervening night of the incident, the informant found his almari door broken, found his almari door open, broken लिख दिया, almari door and lock and grill of the almirah broken. And they immediately informed the police. And the police pursued the miscreant who ransacked who broke into the petitioner informant's house. during investigation, gold chain, gold ring, etc. were found missing from the petitioner's house. This informant's house, informant's house, and an FIR was lodged in connection with this case. This petitioner has been arrested in connection with the incident. Full stop. The learned additional PPS submitted that there are some incriminating materials in the case diary against the petitioner. Full stop. I have scrutinized the case diary. Full stop. It appears that there are some incriminating materials in the case diary against the petitioner. I have considered the length of detention and the progress of investigation. It appears that custodial detention may not be required for further progress of investigation. Petitioner is enlarged on, considering all aspects, the petitioner is enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the learned CGM Kamrup Metro under the condition that the petitioner shall refrain from such activities with which he is alleged. The petitioner shall appear before the IO on every fortnight till completion of investigation, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any bail conditions, the jurisdictional court stroke Eleka magistrate is at liberty to grant cancel the bail granted to the petitioner. Send back the CD.
Highly obliged.
21 Lordship, we have not received the case diary. CD not received.
CDS call for is not received. Issue reminder, list the matter on.
Are you an interim?
Interim order shall remain in force till then.
22 also same prayer. Lordship. We have not received
CDS
the
call
case
for
diary.
is not received. Issue reminder, list the matter on. Interim order shall remain in force till then.
Interim order may come.
Item 25.
25 Lordship, up to date CD was called for, but CD up to date CD not received.
They have been enjoying their interim.
CD is not received.
Updated CD has been called for several times.
But not
Not received. We'll need the CD. 24.
22.
22. এতিয়া ডেট দিলে যাব
22 এই মাত্ৰ কৰিলো। Can't help it.
Up to date.
We'll need the CD. Interim already granted.
It's almost 1 year.
Almost 1 year.
Almost.
Positively লিখি দিয়া. Call for the up-to-date CD positively without fail.
লিখি দিয়া। 7th of May.
So next day you come before it's called out, then you will consider without the CD. Next date.
25 also Lordship CD received, but it was not taken back. Up to date CD was called for.
My lord, the update CD or
CD is not up to date.
my lord, my
You are on interim bail.
I'm
Is it interim?
bail, my lord.
It was up to date on 5/9/2024.
CD, CD is not up to date. Send back the CD. Call for the updated CD. List the matter. Interim order shall remain in force till then.
I'm deeply obliged.
May it please your lordship. Lordship, this is an anticipated bail application, lordship. I am on interim bail, lordship.
So he has appeared, Lordship, statement recorded.
Okay, heard learned counsel Mr. B. Chaudhary for the petitioner. So and so, নামটো লিখি দিবা দেই, who has filed this application under section 482 of the BNWS with prayer for clearance bail as is apprehending arrest in connection with so and so PS case under so and so section. এটা হেৰি মই কৈছো তোমাক এইটো হেৰি order dated 27/1/2025 paragraph 1 খালি হেৰি additional PP জেগাত এয়াও নামটো লিখি দিবা DP গোস্বামী paragraph 1 number দিয়া নাই কিন্তু paragraphত paragraph 2 paragraph 3 তাৰপিছত মোৰ ডিটেকশ্যনটো লৈ লোৱা I have considered the submissions at the bar. I have also scrutinized the case diary. The petitioner has appeared before the IO and his statement has been recorded. The petitioner has not violated any bail conditions. Interim bail was granted by a coordinate bench of this court into the petitioner. Order dated 27/1/2025. Considering all aspects, this interim order is hereby made absolute.
Highly obliged, Lordship. Obliged.
Send back to CD.
Obliged.
Item 27 and 28.
My lord, item 27, today is my lord fifth date, my lord. Fifth time CD has not been received and
CD, you have not received.
Not received, Lordship.
fifth time, my lord.
PG not received, 28 is interim was granted on the other.
27 is not interim, my lord. It is coming on, my lord. Petitioner is the sole bread earner, my lord. Lordship may at least consider my interim pair, my
What
lord.
is the, Harry, what is the,
Victim girl kidnapping.
where is the FIR?
FIR, Lordship. FIR is case, particular portion is case 12, my lord. On presumption, my lord, FIR was lost there. Her daughter has been kidnapped by this present accused person as there was a love affair. Victim girl has already been recovered, my lord, on 11/12/2024, my lord. Victim girl has already been recovered. My lord, I may be.
Do you have any order where it shows that victim girl has been recovered?
I think they have not approached the session court.
Huh?
Any court you have approached?
No, my lord.
Then how will I pass any order on submission? You bring a copy of order that the victim girl has been recovered. CDS call for is not received. Issue reminder, list the matter on. You are not in custody also.
Fifth time, my lord.
9th April. You
Short date, my lord. Short date before
huh?
9th, my lord. Short date because it's already fifth time, my lord.
You give some certified copy or something that the victim girl has been recorded, or you give a
I will try, my lord.
submit an affidavit.
Lordship, date, short date may be fixed, my lord.
Not shorter than 9th. Oh, interim আছে. 28 CD is not received. Issue reminder, list the matter on 9th April. আৰু 28 একেটা order খালি এটা extra sentence add কৰি দিবা. Interim order shall remain in force till then.
Obliged, my lord.
Item 31.
The lordship. Anticipated bail application FIR is on page 11.
You have the CD?
Yes, Lordship.
There are 3 accused persons named in the FIR. One is already enlarged on bail, and 2 have made this.
Please read the FIR.
Yeah. It is humbly prayed that on 5/10/2024 at about 5 p.m. when I, along with my nephew, namely Zakaria Ahmed, returned home from Lakshmipur Tea Garden after plowing a field with cow and buffalo, the above named accused person suddenly attacked us with dao and lathi from the forest, and also with intention to kill me, they tried to hit my neck and dao. As I tried to resist their attack, my cheek was badly injured and my teeth were fractured. They also injured.
All right. What do you have?
Injury report, Lordship. Laceration of the 6 into 4 into 1.5 cm left cheek. Laceration 6 into 4 into 1.5 cm left thumb. Laceration 3 into 2 into 1 cm left index finger. One is in a previous injury and another one is simple injury. Lordship. All are laceration of the Lordship.
Previous injury by sharp weapon or blunt weapon?
Is
Grievous injury, simple injury, and other victims sustained severe injuries on
weapons is not reflected in a medical report.
Just one person has already enlarged on bail. So the investigation already.
That injured, what is his name? That injured person?
That person name is Sahabul Islam.
So what they who
And one is this
caused the grievous injury?
Zakaria Ahmed.
According to Sahabul Islam. Who has sustained a grievous injury?
His name is
was
Zakaria Ahmed.
Zakaria Ahmed. So Zakaria Ahmed has that grievous injury caused on which part? On his cheek or which part? Which injury?
Right parietal region, left arm.
Huh?
And MCT of brain, protein cortical homogenic contusions on left central hemisphere along with.
Let me see.
Lordship. Second to grievous. Simple and grievous. Here Sahabul Islam is the complainant.
His statement is not recorded. That Zakaria Ahmed's
That not
statement is
recorded.
not recorded.
Only complainant statement are there. Only
So we'll need his statement,
Statement.
Zakaria.
not.
Complainant, I'll just check. He is sustained that brain hemorrhage. Mm. What is the complainant's name?
Sahabul Islam.
Sahabul Islam.
Let us see. His statement may be recorded. Statement may be recorded, Lordship. Then, and without his statement, this person cannot be identified, Lordship.
Mm. Sometimes complainants identify. Let's see if he can identify. He did not identify who has dealt the Dow blow on the head.
Lordship.
Complainant could not identify. Will reject or will call for the statement of the victim? Statement of the victim. CD is received. CD required to be updated. The statement of the victim, CD to be forwarded along with the statement of the victim, Zakaria Ahmed. All right.
Lordship.
List the matter on 93.
Item 32. It's not your time. He has appeared and a statement recorded, Lordship.
For learned counsel, Mr. J.B. Gogoi.
Yes, sir.
For the petitioner. এইটো লিখাই আছে 13/2/2025 নাম খালি জেপি গগৈ লিখিব লাগিব হা আৰু হেৰি ডিপি গোস্বামী এডিশনাল পিপি ডিপি গোস্বামী পেৰাগ্ৰাফ 1 2 তেনেকে লিখিবা পেৰাগ্ৰাফ 2 পেৰাগ্ৰাফ 3 সেই 13/2/2025 পেৰাগ্ৰাফ 3 পেৰাগ্ৰাফ 4 paragraph 5 6 I have considered the submissions at the bar. I have also scrutinized the case diary. The petitioner has appeared before the IO and his statement has been recorded. The petitioner has not violated any bail conditions. Considering all aspects, the order dated 13/2/2025 is hereby made absolute under the same terms and conditions sent back the CD.
Petitioner is on interim. He has appeared and statement also recorded. Yes.
33 order dated 19/2/2025, paragraph 1. Okay, paragraph 1, paragraph 2 to nilikiba. Paragraph 3 to nilikiba, paragraph 4 to likidiba ha. More pencil 4 will likit hotisu. Order dated 19/2/25. Paragraph 4 will pencil likit hotisu more. Edu likidiba. Yat more paragraph 2 হৈ যাব paragraph 5 এনেকে লিখি থৈছো পেন্সিল দি হা পাছত মুছি দিবা please. I have considered the submissions at the bar. I have also scrutinized the case diary. The petitioner has appeared before the IO and his statement has been recorded. The petitioner has not violated any bail conditions. It appears that Considering all aspects, the interim order dated 19/2/2025 is hereby made absolute under the same terms and conditions. Send back the CD.
Same accused, my lord.
34 also same 30. He has appeared and statement recorded.
34. It off করে দিও, off করে দিও।
No. Hearing.
This is a hearing, appeal hearing. Will he complete the hearing?
Yes, please.
Entire appeal?
In the earlier order, this,
Because today is a hearing day, that is why.
yes.
Mm.
May I please, sir?
Mm.
Okay.
Mm.
It's part of maybe part.
Okay.
Take only 30.
Another day.
I will record it.
Mm. Another day when?
Immediately. Any day.
But within these
Today-
days, we
today
cannot
after
accommodate.
1 hour.
Within these days, we cannot accommodate.
Fix today, Lord. Fix the time today after 1 hour. Yeah. Contravention of ten. No, there are 4
এটা next date কেতিয়া accommodate কৰিব পাৰি? অকল half argument পুৰাও নহয়। At 2 কৰি দিম। 3rd April at 2. Okay, then you can place your submission today. The rest will play. He'll submit at 3rd April at 2. But I'll not keep it as part.
Lordship,
I'll not keep it as part heard, but
tomorrow cannot.
no, not tomorrow. If it will come up before me, it will come up. Otherwise, it will go.
Before 30, please, sir. Or
3rd April at 2.
no, before 30 March, possible. Otherwise, today fix the time, sir.
No, before 30 March, not possible. The appeal hearing. Not
Otherwise,
possible.
today fix.
I have taken. I will hear you, but I will not keep it as part heard.
Yes, sir.
Then next day I will fix it for him as for on 3rd April. If you agree. Otherwise, we can hear you both at 2 on 3rd April. Then, but I'll not keep it as part heard. This is what I'm saying.
Okay, sir. Let us know.
On 3rd April,
Okay. No, I think-
Learned Counsel for the appellant, Mr. M.M. Rahman,
Lordship, my part I will submit.
you will submit today. Okay.
Lordship, in this case, the fact of the case in simple is that on 19,
Mm-mm.
Lordship, on 19/1/2023, Lordship, the Golokganj police was in Nakaseking,
Mm.
near the Golokganj Bazaar.
Mm.
They signaled to vehicle,
Mm.
Centro,
Mm.
Lordship, vehicle bearing registration number AS23C 6256 and AS23K 4199, Lordship. And thereafter they searched the 2 vehicles and found some plastic wrap packets inside the vehicle. That means inside the body, Lordship. Inside the engine, Lordship. This is the fact, Lord. And accordingly, the case was registered under section 20D clause 2 subclause C, Lordship,
Mm.
and submitted charge sheet. And finally, the session additional judge, special judge session, Dhubri, passed an order and sentenced a rigorous imprisonment of 10 years with a fine of rupees 1 lakh. Lordship. This is the main fact, Lordship. And actual fact of this case, Lordship, on the actually the appellant along with his 3 minor accused here in this case. 3 are minor, and this accused was in 18 years old at that time.
This
Actual fact,
appellant was 18 years old.
yes, at that time. And on that day, he is actually a driver, Lordship, and he drives the dumper at Tripura, Lordship. He is from Tripura. And on that day, what happened? 2 partner, Lordship, from Tripura, namely Yasuf Dev Burman and Dharman Dev Burman, Lordship. And they called him along with the other minor accused person, and they stated that they have sold 2 vehicles to one purchaser at Boxirhat, West Bengal, and they have to take the 2 vehicles by driving the vehicles to Boxirhat.
Where it is mentioned all this?
It is in paragraph number 11, Lord.
11 of what?
My petition.
No.
Actually, it is
No,
not
you must
documented.
take, no, just a moment. Appeal memo or petition?
Lordship,
Appeal memo or petition?
appeal memo.
Appeal memo.
Yes, Lord.
So did you take this plea in the lower court?
Not plea.
Has he mentioned as a DW?
No, Lordship, there is
No, you cannot now
no
bring
any
all this
DW.
story.
In this case, there is no any DW.
Then did he mention in his statement under section 313
Just it is
CRPC?
for court information.
No, I don't want any information. Everything has to be come from records.
Okay, Lordship. After this one, I am going to the record. Lordship, thereafter what happened? Going to the record, Lordship. Kindly let Lordship go to paragraph number 11, Lord.
11 of what?
Of this judgment, Lord.
Yes. Yes. Paragraph 11 of judgment.
Yes, sir. Lordship, PW 4, Lordship. In this paragraph, PW 4 clearly stated in his evidence, Lordship, that police opened the vehicle which hit the police vehicle and recovered the contraband, Lordship. Again, in cross-examination, Lordship, he stated that he does not know whether the appellant has driven the vehicle which hit the police vehicle. He is not clear that which vehicle hit the police vehicle. PW4, Lord. He does not know the contents of the seizure list, Lord. PW4 does not know PW4 Nurul Islam, Lord. He does not know what are the contents of the vehicle. Police only request him to sign on a piece of paper, and accordingly he sign on this paper. That is seizure list. And next, Lordship, paragraph number 19. Paragraph number 8, 9, Lord, of this order, Lord.
Paragraph number 8.
Yes, Lord.
8 of judgment.
Yes, Lord.
Oh, yes.
Lordship, that is PW2 and 3, Lord.
Yes.
Paragraph number 8 is PW2. Lordship, in their evidence, Lordship, police took their signature on a piece of paper. It is written at the bottom of this paragraph, Lordship.
Yes.
Yes. Police took their signature in a piece of paper as witness. Police told him that he is made a witness for the recovery of the said ganja, Lord. Without explaining the details, contents of the list, paper, whatever they have written, just police request him to sign it in the paper, and thereafter police told that he is made a witness for the recovery of the ganja. Lordship, then in cross-examination, does not know the content. In cross-examination, Lordship, PW2 has admitted that he does not remember the registration number of the vehicle, Lordship. That means he does not know nothing about the vehicle, Lordship. He did not read the contents of the seizure list, Lordship, which was not read over to him. Seizure list not read over him, Lordship, at the time of signing of the paper, Lordship. He does not know how much contraband was recovered from those two vehicles, Lord. Police only asked him to put his signature and no further question was asked by the police, Lord. Lordship, accordingly, PW3, Lordship, PW3 in paragraph number 10, Lordship. PW3 also stated in his evidence that police requested him to put some impression in the piece of paper, Lord. Only piece of paper, it is written or not, it is not mentioned here, Lordship. He does not know the content of the seizure. His cross-examination was declined, Lord. Lordship, then let us come to paragraph number 20, Lordship, of this judgment. Paragraph number 20, Lordship. In paragraph number 20, CW1, Lordship, in his cross-examination, explained, Lordship, CW1 has stated that the relevant entry was made on 21/2023. There is no pagination in the Malkhana register, Lord. There is no signature of Tirostadar of Malkhana insert, as well as the OC of Golokganj PS in the register. It is very doubtful, Lordship. During the relevant time, Lordship, one ASI Jadov Bharali was the Malkhana insert and his signature is also not put in the register, Lord. So there is a big doubt, Lordship, regarding the this article, Lordship. Hereafter, Lordship, kindly see paragraph number 21, Lordship. There is self-contradictory, Lordship. PW1, Lord. PW1, it is paragraph number 7, Lord. Kindly go to paragraph number 7, Lord. In paragraph number 7, Lordship, he has not mentioned in his FIR which accused was traveling in which vehicle. There are two vehicles, Lordship. But in the FIR or in his statement, Lordship, the PW1 not stated anywhere that which accused was traveling in which vehicle. It is not mentioned, Lordship. In the FIR, Lordship, a little below, Lordship, in the FIR, as well as his statement recorded under section 161 of CRPC, Lordship, he did not mention that he duly seized all the suspected contraband. He did not mention that he duly seized all the suspected contraband in presence of the independent witness, and seal peg the same and hand over the seized contraband to the Malkhana Sirostadar in presence of OC of Golokganj PS. He did not examine the Malkhana Sirostadar and OC of Golokganj PS under section 161 of CRPC. Lordship, he again admitted that he has not submitted any certificate regarding the authenticity of the pen drive deposited in the instant case log. He also did not submit the camera which is used for recording the videography in the instant case log. Lordship, he is the complainant, Lordship, PW1. And he further again admitted that the authorization letter does not contain the time and issue number of the issuance, and that he received the authorization letter on the next day, Lord, of the incident.
Okay.
But in earlier, Lordship, in evidence,
Mm.
in earlier evidence, he stated as, Lordship, in paragraph number 6, Lordship, at the bottom, Lordship. At paragraph number 6, Lordship, he stated at the bottom,
Mm.
at the same page of paragraph number 7, Lordship.
Yes.
He stated that he duly seized all the suspected contraband in presence of the independent witnesses and seal peg the same and hand over the seized contraband to the Malkhana Sirasada in presence of the OC of Golokganj PS. There is a very big contradiction. Once he said that he duly seized, and again he said that he not duly seized the article. Lordship, and there is another big contradiction here is that okay, there is no issue number, there is no fixed time mentioned, Lordship. And here he is saying that, Lordship, that he received the authorization letter on the next day of the incident, Lordship. But he stated in earlier that on 19th, the same day, he took the vehicle to the police station and seized the article, and on the same day he paid and sealed and sent to the Sirostada, Malkhana Law. But without receiving the authorization letter, how he seized the article, that is a big question. Lordship, in the authorization letter, A1, that is appellant, Lordship, was shown as pedestrian, Lordship, but not as a driver, Lordship. He has shown as a pedestrian, but not as a driver. Okay, there is also a contradiction. He further admitted that he did not mention in paragraph number 7, I am reading, Lordship. He further admitted that he did not mention the name of the police person who accompanied me in the Nakase. He never mentioned in FIR or in his charge sheet, Lordship, or in his evidence in cross-examination also, not mentioned his who accompanied with his Nakase king. Lordship, next, finally, go to paragraph number 16, Lordship. Lordship, paragraph number 16 is PW6, Lordship. Lordship, PW6, in his cross-examination, he stated that, Lordship, none of the witness, paragraph number, PW6 is the IO, Lordship, of this case who has submitted the charge sheet. He stated in his cross-examination that none of the witnesses has mentioned in their statement recorded under section 161 of CRPC that the contraband were sealed and packed at the public place, Lordship. That means the seized article were not sealed and packed at the public place, not before the public, Lordship. As such, the police violates the provision of section 43 of NDPS Act, Lordship. Lordship, the learned trial court failed to give explanation of section 43 of NDPS Act. As such, the entire trial is vitiated, Lordship. Lordship, now let us go at paragraph number 20. Lordship, in this regard, I want to submit a judgment, Lordship, passed by this honorable court. This is the judgment, Lordship.
Yes.
Lordship, this is the same case, Lordship, and this case was also registered by the Golokganj police, Lordship, and trial by the same judge, same court, Lordship. Dhubri additional Judge Dhubri
Yes,
Lordship,
yes.
Special Judge Dhubri, and sentence a rigorous imprisonment of 10 years and also directed to pay a fine of rupees 1 lakh Lordship. Lordship, in this case, appeal is allowed, Lordship, on the ground that the police did not follow the provision of Article Section 51 2, Lordship. Sorry, 51A of NDPS Act.
52A.
52A of NDPS
But
Act.
nowadays, there's a new judgment, no?
Yes, Lordship.
This is 2024, 2025, a new judgment has come.
Lordship.
Section 52A, just contrary, Supreme Court judgment.
Yes, sir. Yes, sir.
So
My
section
submission is
52A does not
my
get trial.
submission is, Lordship. In my case, Lordship, police did not follow the provision of Article 42, Section 42 and 43 of NDPS Act. And similarly, in this judgment, Lordship, police did not follow the provision of Section 42A of NDPS Act. And in the last paragraph on this, Lordship, I'll go to the last paragraph of this judgment. In this judgment, Lordship, it is written, another aspect of the matter is regarding the seizure and safe custody of the seizure contraband law. And blah blah. I am going to the last line of this case, Lordship. However, these two witnesses, there are two witnesses, PW1 and PW2, Lordship. They stated that some incident happened on dated so and so. Lordship. So again, it is saying that, however, these two witnesses have not deposed anything about the factum that the seized contraband were sealed immediately at the spot, recovered in their presence, or they had seen sealing of the recovered contraband. Lordship. PW4, who was posted as the office in charge of the police station, could not throw any light whether the contraband were seized, Lordship. He admitted that there is no mention of time in the seizure list. In my case also, Lordship, there is no mention any time, Lordship. And there is no description of the seized article in the seizure list, Lordship. And from the prosecution witness, Lordship, there is nothing to suggest how the alleged contraband were seized, Lordship. How and when it was taken to the nearest police station, not mentioned, and how and when the sample were taken. Therefore, a serious doubt has been created as regard time and place of sealing of the alleged contraband and safe custody of such contraband till it was sent to the FSL. For this contravention and for this police not following the proper procedure of the provision of NDPS Act, Lordship, the Honorable Court set aside the sentence of the lower court and quashed the order, Lordship, earlier order in this judgment, Lordship. So similarly, in my case, Lordship, there are so many contraventions among the judgment and witnesses, and especially PW1, that is the complainant, and PW6 is the IO of this case, Lordship. There are so many contraventions, Lordship. And my submission, Lordship, my submission in this case, Lordship, I recorded the statement of 4 accused person, Lordship. I have the statement here under section 161 of CRPC, but all the statement written are same, Lordship. Statement are
No, no, no.
Lordship.
This I will not accept, this argument.
Okay, Lordship. Lordship, for that, the mens rea of narcotic, this contravention relates that mens rea of narcotic business is totally absent in the FIR as well as the evidence of PW2 and 3, Lordship. As such, the impugned judgment and order of sentence is bad in the eye of law, Lordship. That's why the sentence should be quashed, Lordship. Lordship, there is a serious contravention between the witness in respect of the incident lawsuit. Regarding the witness of PW1, I have already told lawsuit, is self-contradictory here. Lawsuit. And due to various contravention among FIR evidence of PW1, the credibility of FIR search, seizure and evidence of PW1 are clearly doubtful here. Therefore, my submission is that the Honorable Court may quash the order and set aside the sentence of the below court for the interest of the.
Yes.
And one small submission, this is my submission. Actually, they are the hired driver. He was the hired driver, and driver, he is working as a servant of his master lordship. And if there is any mistake in his course of time, Lord, it should be considered as the act of the master lord under Vicarious Liability Act. But in this case, the Honorable Trial Court does not consider the fact. Lord. Okay, this is my submission.
Manaf, no?
What's it?
Your name?
Name? M.M. Rahman.
Roman.
M.M. Rahman. Mizanur Rahman.
Heard Mizanur.
Yes.
Heard learned counsel, Mr. M.M. Roman. Oh, follow no. Heard learned counsel, Mr. M.M. Roman for the appellant, and learned full stop did, learned additional PP, Mr. K. Boshes submitted for time to place his argument, list the matter on 3rd April.
All right.
You get it upgraded, I think. Just you get it upgraded on that day.
Okay, Lord.
If I am there, of
Okay,
course.
Lord.
If I am not there, no point.
Okay, Lord. All right.
It will be the criminal appeal of this.
Item number 38.
Yes.
Yes.
So this is a case, madam.
You have the CD?
Yes.
Okay.
This is a completely false case, madam. To cover up, madam, her illegal activities, madam, illegal business, madam. Can have a look, madam. Is the FI, madam?
Yes.
Page 9, madam. Married, madam.
Yes.
Madam, with due respect, this is to inform you that I have a hotel at Deotolia on 20/2/2025 at about 7:30 p.m. 3 persons, namely so and so, madam, including the petitioner, madam, of that locality, quarrel and tried to bid with a customer.
Just a minute. Chili nahi nahi. Oh, through the chili hill. Yes.
But with due respect, this is to inform you that I have a hotel at Deohotia on 20/2/2025 at about 7:30 p.m. 3 persons, namely so and so, quarrel and tried to bid with a customer of my hotel without any reason. Quarrel with a customer. When I prevent them from bidding, then they threaten me to face dire consequences and behave indecently, and also threaten me to set fire of my hotel.
We'll come to know. What do you have?
Madam, according to madam, kindly madam, next one. Accordingly, madam, they set fire my hotel at 3:30 a.m. That's at night, morning. And
So
madam,
what do you have? Yes. The hotel was burnt. Seizure list?
But they, madam, the informant, madam, sell liquors, madam, and
on that hotel, my lord. The neighbors, my lord, on various occasions, my lord.
What is the highest offense here that burning the house?
Burning the
One is a 10 years, my lord. It's a 10 years. We are ready to face, my lord. My lord, our my lord, version may be recorded, my lord, at least, my lord. For a my lord, fair trial, fair, my lord, investigation, my lord. We will be protected at least, but we, my lord, your lordship, any conditions, my lord, impose any conditions. Otherwise, my lord, this is purely suspicion, my lord. At 3:30 AM, my lord, there may not be any witnesses, my lord, to set fire that, we set fire the hotel, my lord. My lord, they, my lord, sell liquors, my lord. Late night, my lord, they are also, they are selling, my lord, liquors, my lord. And any time, my lord, quarrels has taken place, my lord. At 3:30 AM, my lord, there may not be, my lord, any witnesses, my lord. You also put any conditions, my lord, we are ready to face, my lord, and cooperating with the investigation, my lord.
I would. What about
My lord, kindly.
Oh, it is just given statement that they have burned the hotel.
Kindly, my lord, is, my lord, petitioner number 1 is about 46 years old, my lord, and petitioner number 2 is 27 years. So there must be some intentions, my lord, to set fire to the hotel, my lord. There is no personal, my lord, rivalry between them, my lord. There must be some personal rivalry to set fire to the hotel.
Petitioner number 1 is the ringleader.
He's a 47 years, my lord, petitioner number
He is
2
the
my lord.
ringleader. Petitioner number 1.
Main confrontation was took place between the petition number 1 and the informant.
At 3:30 AM, my lord, the hotel was hotel set fire, my lord. And my lord, there may not be any intention. There
Maybe
must be some-
earlier, maybe earlier. Not
Lord,
3 AM, maybe at
this
12.
hotel, my lord, sells liquors, my lord, illegal liquor, my lord. But there are neighboring peoples, my lord, neighboring peoples on various occasions, my lord, asked her to stop selling that liquor. That is the only reason, my lord. At 3:30 PM, my lord, why, my lord, this person go and set fire to hotel, my lord, if there is no rivalry between them? Even, my lord, the quarrel took place not with him, my lord, not with her, my lord, one of a customer, my lord. If a quarrel took place between them, my lord, the informant and the petitioners, my lord, then, my lord, there may be some reasons, my lord, to set fire to the hotel. But quarrel took place between a customer, my lord. The customer was asked to leave the place because, my lord, he was, my lord, taking liquors, my lord.
You
We
come,
are
you
legal
come
person.
after some time. Now I'm rejecting it.
We are, my lord, this is AB, my
After
lord.
some time you come.
No, this is AB, my lord.
Huh?
This is AB.
That is why I'm rejecting it. You come after some time, not arrested as yet.
My lord, we are ready to face, my lord. Your lordship, then, my lord, your lordship, protect me in my lord.
No.
I was,
No.
the statement has been recorded, my lord.
No.
After
Sorry, no.
coming, sometimes, my lord, after arresting, my lord.
No. You can
After
come
coming
before-
sometimes,
before,
is
you can
amounting
come
to after
before
arresting, my
that.
lord.
You
That
can come
after
before
arresting,
that.
my lord, no purpose is, but my
Uh,
version has to be recorded, man. At least my version has to be recorded.
You see,
But
there are
this is
certain
the
types
version,
of cases where anticipatory bail
this is the
must
version of,
be granted.
no,
And
that
there
this
are
is the,
certain types of cases anticipatory bail should not be granted.
this is the
Certain types
version of the
cases
informant.
must be
My versions
granted.
must be recorded, madam. We are a local people,
I'll
madam.
record your version. I'll record your version, don't worry. Third learned counsel Mr. A. Khanigar for the petitioners Duzana who have filed this application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as they are apprehending arrest in connection with so-and-so PS case under so-and-so sections. Heard Mr. D.P. Goswami learned addition PP Assam. The allegation against the petitioners is that both the petitioners had a quarrel, the petitioner number one had a quarrel with the informant and
Not informant. With a customer. Well, that's why, Malad, I'm submitting. With a customer of the informant, madam. Put it.
had a quarrel with a customer of the informant and thereafter in the intervening night the petitioners have set ablaze the informant's hotel full stop. It is submitted on behalf of the petitioner that there appears to be no justified reason why after having a quarrel with the customer the petitioners will set ablaze the informant's hotel. Then where is your ground?
Madam?
What do you want to submit? What you were saying, no? What is your plea?
Well, there's no rivalry between them, madam.
It is further submitted that there is no rivalry between the petitioner and the informant,
And the informant, madam, sell illegal liquors, madam.
which will prompt the petitioner to set ablaze the informant's hotel. Full stop. It is further submitted that the informant runs a hotel selling illegal liquor,
And madam, the petitioner tried to, madam, stop that.
and the petitioner
Asked on
tried.
various occasions.
Then how can there be no dispute? Then the dispute is already there.
So this is not only petitioner, but numerous people, all are numerous people.
And the informant used to sell illegal liquor in the hotel, and the petitioner and the neighbors tried to stop the illegal trade. The learned additional PP has submitted that they are incriminating materials in the case diary against the petitioner. I have also scrutinized the case diary. At this juncture, there appears to be no justified ground to extend the privilege of anticipatory bail to the petitioners. Petition stands rejected at this stage. At this stage, you can come later. Send back the CD.
Developed.
It is closed.
Yes. But in this case, your lordship will find the one branch manager of a bank, right? He was initially at Dibrugarh. I am from Dibrugarh, man. And that bank manager, what he did when he came back to Dhula, from where he was transferred to Dhula.
Hola.
Dhula. Yeah, Dhula.
Mm.
So, what he did, my lord, after coming to Dhula, he has sanctioned some amount in the name of his known person. My lord. Suppose I am also one of the customers at Dibrugarh Bank, my lord. 18 persons he has chosen. Again, the 18 he sanctioned some loan and he disbursed the loan, and thereafter he himself would draw the money. Now, when we came to know, so I came to know, I have gone to the branch manager, new branch manager. The branch manager says that RDF beneficiary he was put in suspension and the inquiry is going on. And that's why he was also arrested and he also got bail from the court. That manager who did it. So our name is not there. But RDA also one person filed a case. There I came before this honorable court, after that I in the same footing. 18 persons have taken loan from the bank. The bank was used, 18% bank used. So my humble prayer is I notice everything is against this manager, my lord, and we become the victim of circumstances, my lord. Your lordship will find FIR is page 13. Nothing, no whisper against any of the customers, my lord. Customer means my lord, account holder. Page 13. And period is 6-9, he was Mr. Padut, he was initially my branch manager of Dibrugarh, and then he came to Dhola, 6-9-23 to 11-7-24. During this period, he has committed all these mistakes. Now, page 13 is the FIR. your lordship will find. I have also filed one FIR. After knowing that my account has been used by, I have gone to him. He said, oh, by mistake, some money has been credited in an account and it has been withdrawn by mistake also. So I have corrected it. When I came to know whether he is doing all these things, then I myself filed an FIR, madam, your lordship will find page 19. I myself filed an FIR, madam. And that FIR also, your lordship will find, it was registered on the phone, but it was filed. It was received also, your lordship, page 20, bottom. Received also. So I have done my part, inquiry is going on. Now police is after me, my lord, because your lordship knows once case is filed, sometimes some innocent
Receipt
people.
but case was not registered.
No, that, but receipt is there, your lordship.
Yeah, it's okay.
Receipt is there.
Lordship, the main accused, Pradyut Kaur, confessed that in his statement that the fraud loan amount was transferred to this petitioner, Mr. Sanjeev Kumar Mahato. And it was found that Sanjeev Kumar Mahato also did not inform the bank about the same transaction. And it's proved that the involvement of the case of this petitioner. And also, it is to be noted that another 2 case also has been registered against them, lordship, and Dibrugarh PS case number so and so. And in the statement of the Pradyut Kaur, he stated that all the amount he transferred to this petitioner, lordship. So involvement is there, lordship. And there is a
Account was used, my lord.
there is a fraud
That
of
I was, I
crore
have
of
next
rupees,
class of
lordship.
not that certainly it will be in the trial matter. At this stage, my lord, on the face of prayer.
Lordship, that's CD and there is statement of
My
accused,
question is
lordship.
whether I had any knowledge in that, whether I had a nexus with him or not. My information that he has used not only my account, other money 17% also there. And one of them also filed case against him. In that case also, my lord,
Where is your submission, in which paragraph?
yes, my submission your lordship will find in paragraph 4.
Paragraph 4, no?
4, my lord.
I'll pass an order later. I'll go
Okay.
through the CD and pass an order later.
Yes, and your lordship, submission 4, yes. 4, 6 also, 4, 5, 6 your lordship.
I'll go through it.
Yes, my lord.
4, 5,
And
6.
my
And I remember I'll pass an order today itself.
yes, my FIR is page 19.
I just mentioned in the index, no?
Yes.
Index.
Mention.
I'll go through it all. A small case, small
Yes,
petition.
yes, my lord.
Not a huge
No, for your
record.
lordship, it is smaller, my lord.
I am unable to handle the cases these days. So many cases.
Obliged, your manager.
All flag mark, no?
My lord, manager got paid, my lord, from the court below. Can you, we may.
Okay, yes.
Kumar, my certificate is not there, my lord, but, oh, certificate, okay. Photocopy, my lord.
It's
Photocopy,
okay.
certificate.
It's okay.
Yeah.
Pending item 15.
15.
That video notice. Here, this is second bail application notice. Earlier bail application was rejected on 7/6/2024. That starts from page 27. And Lordship may kindly see the paragraph, page 30, paragraph 10, Lordship. In view of the foregoing discussion, petition with prayer for bail cannot be allowed at this stage. Bail petition stands rejected at this juncture. However, the petitioner is at liberty to apply for bail if trial is procurated and procrastinated for the prosecution or by the court. Now here, Lordship, after rejection of this case, only 2 witnesses were examined till now. Out of, Lordship, that 7 witnesses. And second, Lordship, my ground is that, Lordship, that from the arrest memo, your Lordship will find that no grounds were communicated to the petitioner, Lordship. Just in this regard, Lordship, I am relying on Lordship Honorable Apex Court judgment that Bihan Kumar's case, Lordship.
Page number where?
Bihan Kumar's, Lordship,
No, no, Bhyan Kumar judgment I have read, but Apex Court, no, this
Ground of arrest.
no grounds of arrest
That in the
communicated.
records are here.
So when you come up with this plea, I will
No,
have to
that is
give
why
them,
I'm
PP also will have to give them some time to
Okay.
file their submission. Because see, you see, this is a fully contested case. Both the parties have contested.
Lord.
Here, I'll have to give them some time. Huh? Okay.
That- And even in fact, Lordship, in
I'll give
1976,
them some time to file an objection.
Lord.
and in fact, 1976, our division bench High Court judgment also says that section 50 is mandatory, that communication of ground.
Yes, yes.
Only sorted, Lordship, that if it is, only thing is that whether it
I
was
think section 50 is complied with. I have seen many cases with grounds.
in probably
But
in
now
my
I
case,
don't
it is
know why
not there.
these cases are coming up because whenever we forward an accused,
But-
the accused is always asked, do you have injuries? Then do
No, that
means-
oral communication will not do, because Lordship, it has
No,
been
but we
clarified.
check the arrest memo also and then this section 50 also. We check their grounds are always written.
No, Lordship.
Ah.
Probably Lordship has checked it, but now in
No.
some cases, what we find, Lordship, probably your Lordship will also find in this case also. I have flag marked it in the LCR. That arrest memo and inspection memo says, Lordship, that no grounds were communicated to him. And grounds and reasons for arrest, those are two different things. Lordship.
Here no grounds are communicated.
No,
Let
not
me see,
communicated.
just let me see.
That grounds of arrest, Lordship may kindly see in the
Page? Grounds
So in the records, it is there. Arrest,
Oh, in the
the
record,
arrest
okay.
memo. Because arrest memo has to be given to the accused in terms of section 52 of the NDPS Act
Mm.
and 50 of CRPC, earlier CRPC.
In arrest memo, grounds are not written.
So that is the crux in the present case. Even in Bhyan Kumar's case also, that is the crux.
Mm.
Because forwarding report, I am not going into that aspect. Because
In arrest
forwarding
memo is
report
not
is
written, but
different.
section 50, there is another format.
Yes.
Their grounds are written.
If it is communicated to the accused, then the accused have no case. But if it is not communicated to the accused, then it is a ground for bail.
You check them.
Lordship, I have to go through
There,
the
there's,
record and also have to-
there's another format, section 50. There's an arrest memo, is Das is sitting there, he will know. There's another format, section 50, and there's an arrest memo also. So you have to check.
No, there are two, three different sections. There's a section 47, 48, and section 50. And section 47 relates to communicating the grounds to the accused.
Yes.
That is the
Yes.
arrest memo.
Yes.
And Lordship, what Bhyan Kumar says, Lordship, that subject to correction, Lordship, and what I find from the coordinate bench judgment, it says that the arrest memo which was furnished to the accused under section 47, it must contain the grounds of his arrest. That is the case. Lordship. I am not saying that other documents may not show the ground. Other documents may show. That is not the case. Even if your Lordship see the Bhyan Kumar's case, paragraph
Which part?
21.
Arrest memo? No, paragraph 21 I have read.
Lord.
Anywhere about arrest memo, which paragraph?
Arrest memo, Lordship, that is in the record. I could not annex in my petition.
No. Which part of the judgment
Yes, ma'am. Lordship, that
about arrest memo?
about arrest memo, just I'm checking there. Section 50, Lord. Paragraph 9.
Paragraph 9 is submission.
No, Lord. Paragraph 9 is that Article 22 Constitution, that is
That is not required here.
then your Lordship will find the next page, section 50. Section 50 CRPC, that is section 47 of BNSS, which reads as under
Where?
paragraph 9, okay. It is continued after the article is quoted. Then section 50 is quoted.
Yes.
Every police officer or other person arresting any person without warrant shall forthwith.
Yeah, this is there.
It is
Section
there.
50 in all the court cases, the grounds are mentioned. You are arrested under this and this section and you will apply for bail. This is mentioned.
No, in the present case,
In
which
not
I have-
mentioned?
It is not mentioned.
Okay,
That
okay.
is what I am placing for your Lordship. And in fact, section 52 of the NDPS Act also says that grounds of arrest has to be communicated to the accused. That is in perimeter with that section 50 of CRP.
Section 52 is not section 47.
No, the Lordship may kindly say section 52 of NDPS Act.
NDPS Act, no?
Yes.
But now we are not
52.
going to section 52, no? But here this case, Vihan is dealing with only this 50 and 47.
50, 47
article-
and PMLA. PMLA.
And PMLA and
Yes,
article.
in that case also that 45 is there, that is, the twin conditions
Yes,
are
yes.
there, similar to our case. And in paragraph 21, it is said that if it is established, the word I am using is
Yeah, I know, paragraph 20, I know.
Yes,
That
yes,
statutory.
yes, I'm stressing on the word established because if from the record I can show your lordship that the article 21 is violated, then itself is a ground for bail. Therefore, I'm referring to the records.
Yes, you find out.
Lordship, I have to,
This is a fully, if you follow Vihan command, then we'll have to give them some time also. You find out if you don't have the grounds, then
written
no.
objection.
Then we have to grant bail.
Weeks time may be given.
Hmm?
2 weeks.
Weeks is
No, 2 weeks is too much. 2 weeks is too much.
Next week, any date. Lordship.
Judgment, very small, little, tiny little.
They will peruse the record. If it is there, it is there. It is not
Lordship,
there, not there. That's much.
Yes.
I will peruse.
You read the judgment also thoroughly.
Lordship.
Maybe I have repeatedly read it, maybe once or twice. Because this has come up as a now everybody is bringing this all the time, and without knowing this, I cannot pass order also. So I have read it repeatedly.
Yes, sir. Today is 15, no?
Then Bihan Kumar is passed recently, Lordship.
Huh?
Bihan Kumar is
Yes,
passed
yes.
recently, but
Yes.
our division bench has passed in the year 1976.
1976, true. Long time back. Very দুসপ্তাহ নিদিবা date of this.
Next week, any date. Lord.
Third learner counsel Mr. A. Ahmed for the petitioner
Any-
and learner additional PP Miss N. Das for the respondent state. Post of the learner additional PP has submitted for time to place her objection. List the matter on
9th of April, না থাকে 7-8.
7 and 8, I have some different.
9th.
Lordship.
Apply.
Item 40 for orders.
Lordship, service is complete.
Okay,
Service is
then we'll
but
place it for
no one
admission.
has appeared.
They have not appeared. Their names are given? No, names are not given. Learned counsel Miss
As Soikia.
S.
Soikia.
Soikia is present for the appellant.
And
Appeal.
Lordship, the LCR may be
Petitioner.
called for.
Yes. Then we will fix another date then.
Yes.
Without going proceeding for admission, we'll fix another date then.
Another,
Okay. Huh?
Lordship
Or
will fix it for.
admission.
Yes.
AD card in respect of has been received back after service. Office note indicates that office note dated 21/3/2025 indicates that AD card has been received back after service of notice on the respondent. The respondent is not represented today. Call for the trial court records. List the matter for admission. After 2 weeks.
Item 41.
Maybe not. Maybe, in this case, notice issued on 5/3 by the registry. So it may come in the first week of April. Lord.
Okay.
It will be over. 1 month will be over by that time. 30 days time will be over by that time. Issuing the notice.
So we have not received anything back, so service report is awaited.
Service will be awaited. Lord, may fix a date. Lord.
Date?
Yes.
Learned counsel Mr.
Also.
Arsoma is present for the petitioner. Service report on respondent number 2 is awaited. Learned additional PP Mr. DP Goswami is present for the respondent state. list the matter on 10th April.
So only one thing, Lordship. In this case, I am for the accused. The complaint petition was dismissed by the trial court. That was challenged before the Honorable Session Judge. And the Honorable Session Judge allowed that petition against that I am coming. So already trial has already begun there, the court below. And if that trial is not stayed, then my filing of this petition shall be infructuous. So I am fair for stay. And the informant is not appearing in the case.
Then let us call for the LCR then.
LCR has been received. Lordship.
Have we received the LCR?
The policy is there.
So next day, then if information is not received, then we'll go to the culture. LCR is not done so by us. We have to go to
Next
it.
date, we'll take up at next date.
I mean,
Matter of prayer
some
shall be, the prayer for stay will be considered on the next date.
Next day.
Obliged.
May be considered, yeah, shall not, and may be considered on the next date. Yes, yes.
Fine. Next is your Lordship, my lord. Their petitioner was convicted under the POSCO Act, my lord. Under section 4, my lord.
Yes,
He wants the sentence to be reduced, that is what he's asking.
that is only my that case, my lord. And in this regard, I have submitted a judgment of Allahabad High Court, my lord. Similar effect.
What do you want to say? I dispose this for I.
This was for the pay. Because it's a matter of final. It's a big funding.
He won't be released, he will be taken to Motia.
Yes.
He is a Bangladeshi national, he will be taken to Motia.
Kindly consider, my lord, let him to go. Why Assam government is taking pardon?
No, they have deported, that day they have
Yes,
deported. 13 they have deported recently.
As per Supreme Court. And this is, my lord, admittedly, he is
Because
Bangladesh.
there, when they are sending,